Good morning, everybody. We are going to be starting birthright citizenship here in just a bit, but I will cover some background on this case. So, the question we're going to be looking at today is going to be the Citizenship Clause of the 14th Amendment provides that those born in the United States and subject to the jurisdiction thereof are U.S. citizens. U.S. Constitutional Amendment 14, Section 1. The clause was adopted to confer citizenship on the newly freed slaves and their children, not on the children of aliens temporarily visiting the United States or of illegal aliens. On January 20th, 2025, President Trump issued Executive Order number 14,160, protecting the meaning and value of American citizenship, which restores the original meaning of the Citizenship Clause and provides on, hello. Good morning, guys. I'm just going through this real quick and we're going to start soon. Which restores the original meaning of the Citizenship Clause and provides, on prospective basis only, that children of temporary visitors and illegal aliens are not U.S. citizens by birth. The Citizenship Order directs federal agencies not to issue or accept citizenship documents for children born more than 30 days after the order's effective date. The question presented is whether the executive order complies on its face with the Citizenship Clause and with 8 U.S.C. 1401A, which codifies that clause. So I'll just go into a little bit of background here on what they're actually wanting to look at. So, subject to the jurisdiction thereof is a complex matter, but it can be broken down very simply. Can we charge you with a crime? Are you subject to the laws of the United States? Now, if anybody knows about foreign diplomats, they cannot be charged with crimes here in the United States. So I want to read this one portion of their cert petition because it's very interesting. It says, the clause, however, does not, however, grant citizenship to the children of temporary visitors or illegal aliens. The plain text of this clause, in its original understanding and history, and this court's cases confirm that the clause extends to children who are completely subject to the political jurisdiction of the United States. And no, the fuck it doesn't. Meaning that they owe direct and immediate allegiance to the nation and may proclaim its protection. As this court has recognized, children of citizens and those who have permanent domicile and residence in the United States meet that criteria. This court's earliest cases interpreting the 14th Amendment explicitly reject the notion that anyone born in the United States territory, no matter the circumstances, is automatically a citizen so long as he is subject to U.S. law. That comes from the slaughterhouse cases. So we're going to be gearing up for this here in just a few minutes. I believe Law and Attorney Dye are going to join. Just waiting on them. Hold on, let me see if I can share it. But yeah, we'll be starting here in just a few minutes. Apparently, Trump is going to be there, which is crazy to me because it's going to turn this into a political spectacle. And also, people that may have had tickets to attend may not be able to, which pisses me off. If you do not know anything about Supreme Court cases or trying to attend them, it's actually rather difficult. You go into a lottery pool. I don't know, Googs. So you go into a lottery pool to get these tickets. For instance, I have applied for at least 5 different months in this Supreme Court session, and I have not been granted tickets. So it's really, really frustrating that, like, you know, you could do all that work and then not be able to get in there. And if I get tickets next year, I will go to DC and try to do some live stuff. But yeah, so we're gonna be starting soon. And hopefully we'll get ready to go. Let me see if they're already prepped. Give me 1 second. If you've never watched these with me, We're pretty chill in here. I do try to answer questions, but it's very hard to pause during live oral arguments, which is why I always encourage people to be here a little bit early, because I'll try to brief on the case. But really, this is just, does this executive order violate the 14th Amendment on its face? That's the real question that we're asking. Sorry, guys, I woke up with a little cough and cold this morning. My allergies are out of control. We'll wait for Law to get here. Goog, can you share this with Law, babes? Because I can't do it from my damn TikTok studio. I'm crap at that. Oh, thank you, Google. I appreciate you. But anyway, so does anybody have questions about what's going to happen today? Go ahead and throw them in the chat while we're waiting. And then as soon as this starts, we will be ready to go. Let's see. Like, this is going to be a very interesting argument. I find some irony that it's both Ash Wednesday and April Fool's Day. Yes, I did hear that Trump is going to be there. I was talking about that a little bit earlier. I think it's a distractive process. I don't think it's good for court integrity, but, you know, is what it is. And we are getting ready to go. Let's see. Let me hit play again. Nope, it's just running through. As soon as this starts, we'll be ready. Hello, good morning, everybody. I so appreciate you all for being here. As soon as this gets going, you know we will listen to it and get into it. But we are ready to go, because I need to hear this. I got to hear this. Let's see. Okay, well, it's not running through, so whenever it starts, and I'll shut the fuck up. Yeah, so if you don't know me, and somebody actually reached out to me and wanted to share my lives. So I do Supreme Court lives. I'm Cass. I am a paralegal. Now, I try to do this in a way, yeah, Goog, he may be in court. I know he's been running around today, so he'll be here when he gets here. Whenever they get here, they get here. I do bring Law of the Wild. That's my boss. And Attorney Di said she was going to come by today. But if you don't know about my lives, I do Supreme Court lives where I just break down the court in a way that's simple to understand. I am not perfect. I am not an attorney. This is just a very simplified breakdown of kind of what I'm hearing, what I'm seeing, and where I see the vibe going. Now, if that's not for you, that's great. There are plenty of very educated attorneys on this app. I do try to have my boss, Law of the Wild, come up a lot. But at the end of the day, you know, it's absolutely your choice whether you want to vibe with me or not. But we just chill in here. We laugh at stuff. We make fun of Justice Alito because nobody likes Alito. You know, we just have a good time. Good morning, everybody. Y'all are so amazing, and we are just waiting on this to start, guys. So. Trump is such a king that he checks those verses. You know, it's oh, god damn it, Price, not Mod. Not the DoorDash attorney. Yeah, like if y'all like, and honestly, I don't care if you can just tap and like follow and you know all the shits, like that helps a lot. But we are waiting on this to start. If you do have questions, put them in the chat. I'll do my best to get to them before this gets going. Usually they're supposed to start at 9, but they start at like 9:05. Let's be so real. Because if you've worked in the court system, you can appreciate this. Not a goddamn thing runs on time. I love that because not a goddamn thing runs on time. Ever, 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 ever. You think it's going to be at 1? No, it's going to be at 3:30. Because just like medical care, sometimes things run longer than you expect. Or sometimes more people show up than you expect. Pedro, asked, do you think it may backfire on Trump by being there? Well, that's really the question, isn't it? Potentially, I could be seen not legally, but maybe as like kind of like intimidating practice. I would say Trump being there only really serves as a distraction from things that are important. I would say if it's John Sauer even, he's probably shitting a brick, and it's probably going to be Sauer that argues this if I had to guess. Yeah, I don't think Roberts will like it either, Monty. I feel like the originalists are really going to struggle with this because when we look back to the original arguments in Senate hearings, we see them discussing this at length. And, it's made very clear that this term of political jurisdiction wasn't their major concern. So I think that they're going to wrestle with this. I do. I don't think it's going to be as cut and dry as we want it to be. I think we can already guess it's going to be Thomas and Alito that are like, licking Trump's sack. But aside from that, I think you're kind of more, because I'll give this. Gorsuch and Kavanaugh can surprise you. So can Barrett. As much as like I can have my own feelings about them as people, Gorsuch is my favorite, actually, spicy judge. When he gets mad, it's so fucking hilarious. He will like get so. Oh, here we go.
Your argument this morning in case 25-365, Trump versus Barbara. General Sauer.
Mr. Chief Justice, and may it please the court. The Citizenship Clause was adopted just after the Civil War to grant citizenship to the newly freed slaves and their children, whose allegiance to the United States had been established by generations of domicile here. It did not grant citizenship to the children of temporary visitors or illegal aliens who have no such allegiance. This conclusion reflects the original public meaning of the clause. When Congress used the term "not subject to any foreign power" in the Civil Rights Act of 1866, it rejected the British conception of allegiance. Senator Trumbull explained that subject to the jurisdiction thereof in the clause means not owing allegiance to anybody else. And in 1884, this court recognized that subject to the jurisdiction means owing direct and immediate allegiance. The clause thus does not extend citizenship to the children of temporary visa holders or illegal aliens. Unlike the newly freed slaves, those visitors lack direct and immediate allegiance to the United States. For aliens, lawful domicile is the status that creates the requisite allegiance, and the text of the clause presupposes domicile. For decades following the clause's adoption,
that's a strong suggestion.
That the children of temporary visitors are not citizens, and illegal aliens lack the legal capacity to establish domicile here. Unrestricted birthright citizenship contradicts the practice of the overwhelming majority of modern nations. It demeans the priceless and profound gift of American citizenship. It operates as a powerful pull factor for illegal immigration and rewards illegal aliens who not only violate the immigration laws, but also jump in front of those who follow the rules. It has spawned a sprawling industry of birth tourism as uncounted thousands of foreigners from potentially hostile nations have flocked to give birth in the United States in recent decades, creating a whole generation of American citizens abroad with no meaningful ties to the United States. I welcome the court's questions.
General Sauer, before we get into the broader national issues, would you start with Dred Scott? Dred Scott was a case about state citizenship.
Not Thomas asking about Dred Scott.
And of course, we know what Chief Justice Taney did with that. How does the Citizenship Clause respond specifically to Dred Scott and answers or
okay, that's a fair question.
Changes or corrects its answer as to citizenship? The other point is the Citizenship Clause refers not just to national citizenship, but also to state citizenship. Are we to have two different definitions for those? It's one word, citizens of the United States, and citizens of the state wherein they reside. So as you begin, I'd like you to go back at the beginning and be more specific about the answer, and I want you to explain whether or not those two definitions are the same or related, and what state citizenship is based on.
Thank you, Justice Thomas. I'll maybe start by addressing Dred Scott. You know, as you alluded to the fact, Dred Scott, you know, imposed one of the worst injustices in the history of this court, and it led to the outbreak of the Civil War. It's very clear, and this court in all of its early cases interpreting the 14th Amendment said, you know, the one pervading purpose, the main object of the Citizenship Clause is to overrule Dred Scott and establish the citizenship of the freed slaves. And if you look at the debates in the congressional record and discussion surrounding the adoption of the Citizenship Clause, what you see is a very clear understanding that the newly freed slaves and their children have a relationship of domicile. They do not have a relationship to any foreign power. For example, there's a comment where he says, look, people have been here for 5 generations and clearly have no relationships to any foreign African potentate, or have a relationship of allegiance to the United States. And that reinforces our point that allegiance is what the word jurisdiction means. It doesn't mean regulatory jurisdiction or sort of being merely subject to the laws.
Good morning,
They're
Law.
talking and they're thinking about it in those debates about allegiance. Now, as to your second question, if you look at the text of the clause, we believe it says, born in the United States, born or naturalized in the United States and subject to the jurisdiction thereof, are citizens of the United States and the states of which they reside. So there's a constitutional guarantee that applies to both federal or national and state citizenship. And the key point we make there is that word reside, if you look at, for example, section 1473 of Justice Story's commentaries, was understood to mean domicile. So when they say subject to the jurisdiction,
Yeah, did they pull that out of their ass?
The state in which they reside, the very text of the clause itself presupposes that the citizen is domiciled in the United States. If they're present in a state at all, they reside there. Reside means domicile in the Constitution.
We're only one
And we think
question
that
in
strongly
law.
supports our interpretation. It's textual evidence of our domicile-based theory of jurisdiction.
Well, starting with that theory, you obviously put a lot of weight on subject to the jurisdiction there.
Roberts.
But the examples you give to support that strike me as very quirky. Children of ambassadors, children of enemies during a hostile invasion, children on warships. And then you expand it to a whole class of illegal aliens are here in the country. I'm not quite sure how you can get to that big group from such tiny and sort of idiosyncratic examples.
There are those sort of narrow exceptions for ambassador foreign public ships. Tribal Indians is an enormous one that they were very focused on in the debates as well. But what I do is I invite the court to look at the intervening step, which is the enactment of the Civil Rights Act of 1866. And there they didn't say subject to the jurisdiction thereof. There it says not subject to any foreign power.
Yes, this is John Sauer, not
Blackstone and
RFK.
Calvin's case, they say it does not matter if you are subject to any foreign power. If you are born in the king's domains, you have this indefeasible duty of allegiance to
and
the
you're
king
welcome to come
at
up
any
as
time.
well,
so
too,
there's a
babe.
clear repudiation in the Civil Rights Act. The Civil Rights Act is this breakwater which makes it very, very clear that they are not thinking about allegiance in the terms of like the British common law. They've adopted the Republican conception of allegiance. So it's from not subject to any foreign power, and then the debates just a couple months later make it very clear that they're recodifying the same conception. They were dissatisfied with the potential ambiguity in the phrase Indians not taxed, and they adopted subject to the jurisdiction thereof. And one of the strongest statements of this is Senator Trumbull's statement that I quoted at the beginning, where he says, he's asked, what does that mean, subject to the jurisdiction thereof? And he says, it means not owing allegiance to anybody else. That is what it means. And this court picked up on that in Elk against Wilkins when it says, it uses, completely subject to the political jurisdiction, not mere regulatory jurisdiction.
What do you do with
Sotomayor.
Wong Kim Ark's quote of Daniel Webster, who said, independently of a residence, with intention to continue such residence, independently of any domiciliation, independently of the
Started
taking
about
of any
5-10
oath of
minutes ago.
allegiance or renouncing any form of allegiance. It is well known that by the public law, a non-citizen, while he is here in the United States, owes obedience to this country's laws.
Amen.
Now, the examples that Wong Ark Kim used as exceptions are situations in
Did
which
you say
there was
Wong Art
not
Kim? Sorry.
temporary allegiance to the United States. The children of foreign diplomats whose only allegiance was to their foreign country, and or occupied territory residents, including those citizens in Maine who had been occupied by the British forces. The U.S. had no control over them. And the whole theory of the Indian tribes was similar. The Indian tribes were analogized to foreign diplomats. So what do we do with that?
I'd say two things. First, as the Indian tribes, we think that's a case that strongly supports us because, of course, by 1866 and 1868, there was strong understanding that the Indian tribes were subject to the United States' regulatory jurisdiction.
But not the same way that temporary foreigners were, meaning there was a real debate going on whether the U.S. actually had jurisdiction over Indian tribes. That's why our cases, for the longest time,
Yeah,
until
weren't they sovereign
that
nations
was
law?
finally settled, said,
Yeah, and this was
absent
brought up
some
in the
act of
debates about us
Congress,
making treaties
there
with
is,
them.
our laws
Gotcha.
don't apply. U.S. laws don't apply to Indians on Indian lands, correct?
I believe you look at the Rogers decision, for example, that we cite in our brief, where they say that they are subject to the United
That's
States
later. I'm
regulatory
talking at the time.
Yes, at the time. So as to
All right, so
1817.
what do you do during the debates of the 1866 Civil Rights Act and of the 14th Amendment with the entire discussion of the people who opposed the amendment, who kept saying, we can't pass it because we're making citizens of gypsies who have no allegiance to anybody, and we're going to make citizens of Chinese people who can't be citizens because we're not going to permit them to be citizens? What do we do with those debates and the fact that the proponents of both acts said everyone who's born in the U.S. will be citizens?
Oh,
First, as to that particular exchange, page 2890 of the congressional record from 1866, Senator Cowan gives this virulently racist statement where he says that. And what does he say right at the beginning of that sort of offensive speech? He says, we can't have children of gypsies, children of Chinese immigrants, we can't have them become citizens. And he says, quote, have they any more rights than a sojourner in the United States? So he's trying to persuade the Republicans to his view by appealing to a common understanding that sojourners do not have children who become citizens. So this
And what did
pop-off
Conness
legislation,
respond to
everybody
that?
understood
Senator
that.
Conness
To,
responded to that.
Not sweep in the temporary sojourner, and that's
yeah,
why you
I
see
know. I
for
love how they
40,
brought that up.
50
I remember
years, you
that
see
name
every
because you
commentator
sent it
addressing
to
the
me
specific
and you were
question of
like,
temporary
he
presence,
didn't, he
saying
wasn't the one
it's
who
not covered by
prevailed,
the clause,
right?
including for decades after Wong
Yeah,
Kim
he's
Ark.
quoting the
General, can I
arguments of the
take you back
loser of the
to
debate.
Chief Justice's
I
question
love that for
about
him.
the specific exceptions to birthright citizenship that everybody seems to agree
This is fucking
were
Alito.
recognized under the common law. And it brings up an important principle about how we interpret the law. When particular problems pop up, lawmakers may enact a general rule. When they do that, is the application
I need
of that
somebody
general
to make me a
rule
sticker for
limited
my fan
only
chat that
to
says
situations
Alito's the
that
worst?
they had in mind when they adopted the general rule, or do we say they adopted a general rule, they meant for that to apply to later applications that might come up? Justice Scalia had an example that dealt with this situation. He imagined an old theft statute that was enacted well before anybody conceived of a microwave oven, and then afterwards someone is charged with the crime of stealing a microwave oven, and this fellow says, well, I can't be convicted under this because the microwave oven didn't exist at that time. And he dismissed that. There's a general rule there, and you apply it to future applications. And what we're dealing with here is something that was basically unknown at the time when the 14th Amendment was adopted.
What
which
the
is
fuck?
illegal immigration.
Fucking
So how do we deal with that
pretzeling
situation
coward.
when we have a general rule?
Is he
I strongly
advocating
agree
for
with
a
the way that
living
you framed it, that there is a
constitution
general
now? That's
principle
a wild
broad principle that's
take.
adopted in the phrase subject to the jurisdiction thereof. And we submit that our theory of allegiance and domicile-based allegiance is what explains those specific exceptions that everybody was aware of, but it is broad enough to sweep in future situations. And as you pointed out, illegal immigration did not exist then. Now, the problem of temporary visitors did exist. And it's very interesting that as you look at pages 26 and 28 of our brief, commentators going from
This is why Alito is
1881
the
until
worst. I want you all to
1922
know that.
uniformly saying the children of temporary visitors are not included. Now, that logic, we say, it naturally extends. It's really an a fortiori case. If you have someone who enters illegally by the 1880s, there are restrictions on immigration. If you've entered illegally, it's kind of, you know, a well-established principle of law going back to the Code of Justinian that says you're not allowed to be there. You don't have the legal capacity to create domicile there.
But I think, General Sauer, that what you just said suggests that you can't be arguing in the way Justice Alito suggests, because most of your brief is not about illegal aliens. Most of your brief is about people who are just temporarily in the country, where there was quite clearly an experience of, an understanding of,
This
that
is
there were going
Kagan.
to be temporary inhabitants. And your whole theory of the case is built on that group. You don't get to talking about undocumented persons until quite later and at much lesser, I think it's like 10 pages to 3 pages or something like that. So you can't really be going with Justice Alito's theory. You must be saying that there's a principle that developed, that was there at the time of the 14th Amendment. Isn't that right?
We agree there's a principle there at the 14th Amendment. It is jurisdiction means allegiance, the allegiance of and this is very strongly reflected in the 19th century sources, the allegiance of an alien present in another country is determined by domicile. And that goes back to the Venus and the Pizarro. It goes through the Katza Affair in 1853. It comes right
Why?
up to
But America, our laws are different. Who fucking cares?
That are decided shortly before Wong Kim Ark. So that's the principle. That principle clearly applies here. I also respectfully disagree with that.
And I guess,
think,
Mr. General Sauer, where does this principle come from? Allegiance, domicile.
Comes from
Allegiance,
nowhere.
I think
He
you
made it
point
the fuck
to a
up.
Lincoln funeral speech as your primary example of where this principle comes from. It's certainly not what we think of when we think of the word jurisdiction, and I appreciate that jurisdiction has many meanings, but the first meaning is like if you're subject to jurisdiction, you're subject to the authority of. One doesn't say, oh, what that means is a certain kind of allegiance that domiciliaries have and nobody else does. So the text of the clause, I think, does not support you. I think you're sort of looking for some more technical,
So
esoteric
by that
meaning.
own definition, would you
and
have
then
to
the
own a
question comes,
home
okay,
to
if
vote?
the text doesn't support you, if there's a
Domicile?
real history of people
Like
using
if we're
it that way.
really looking
but as
at
far
it
as
the
I
way
can
they're
tell,
framing it?
at the time of the 14th...
Write that down for talking about later.
You're
Gotcha.
using some pretty obscure sources to get to this concept.
Well, I take it straight from the framers' mouths. So, for example, Senator Trumbull was asked, what does jurisdiction mean? He means subject to the jurisdiction. He said, what does that mean? He says it means not owing allegiance to anybody else. He is the principal framer of the Civil Rights Act of 1866. Representative Bigham, who's the framer of the 14th Amendment, is asked, what does it mean in the congressional record at page 1291? He says, within the jurisdiction of the United States of parents not owing allegiance to any foreign sovereignty. And we've cited many, many examples where the congressional debates reflect that. Then you referred to the oration of George Bancroft. That's one of probably 16 sources, but there's at least 13, counting that one in the 12 treatises we cite at pages 26 to 28 of our brief. There is over a dozen sources that specifically address temporary sojourners. In the 5 decades after the enactment of the amendment, every single one of them says, well, temporary sojourners, their children are not included, including for 2 decades after Wong Kim Ark. So,
if domicile's the key linchpin to your argument, and I take it that it is, do we look at how domicile was understood in 1868, or do we look at it how it's understood today in context of the INA?
The 1868 understanding, I'm not aware of a strong difference between those.
Well, here's where I'm going with it. I'm just working within your argument for a moment. Today, you can point to
I don't
laws
like the way
against
he said for a
immigration
moment.
that are much more restrictive than they were in 1860. We really didn't have laws like that we do today until maybe 1880. So if somebody showed up here
Chris,
in 1868
Laws
and
Discord is
established
linked in my
domicile,
link tree because that's
that was
the
perfectly
Discord.
fine without
I'm a mod
respect
in
to
there.
any immigration laws. There they were.
It's Cass's
And
Discord.
so why wouldn't we, even
It's
if we were to
Cass's
apply
Discord.
your own test,
Law owns it. I
come
just
to
run
the
that bitch.
conclusion that the fact that someone might be illegal is immaterial?
I would first cite Wong Kim Ark on that point, because Wong Kim Ark says you're.
Well, I'm not sure how much you want to rely on Wong Kim Ark.
But there is a statement in there that says, so long as they are permitted to be here. So Wong Kim Ark, keep in mind that by the time they decide Wong Kim Ark in 1898.
But that's 1898.
I'm
Now
so
looking
sorry,
at
guys. If y'all can just
1868,
keep
you're
tapping
telling
the
us that
screen,
I should
it
look
helps
in the
me
test
so
for
much. I
domicile.
appreciate every one of you.
And the stuff you have about unlawfully present, it's like Roman law sources you're going to.
First and second restatements as well, and
Yeah, that's
but-
course.
decisions of this court.
Yeah,
Sorry,
but, so it wouldn't be the INA that would control whether you're capable of having domicile. It would be whatever the law was in 1868.
I think that this is addressed by my exchange with Justice Alito from earlier, which is that this concept, jurisdiction, baking in allegiance and domicile is
Congress
applied
could
to.
continually restrict who may lawfully be present more and more, and you'd say that would be incorporated into it, even though you're telling us to apply the original meaning of 1868.
The original meaning of domicile. And so the question is there any argument that the framers intended to preclude Congress from dictating who can and who cannot establish a lawful domicile here? I don't see any evidence of that in the congressional record, so it's a natural extension.
Whose domicile matters? I mean, it's not the
Thank
child,
you.
obviously. It's the parents you'd have us focus on. And, you know, what if, is it the husband? Is it the wife? What if they're unmarried? Whose domicile?
Well,
this is
in the
a
executive
banger.
order, it draws a distinction between the mother and the father, and it's really the mother's domicile. I think that would matter
Well,
there.
but
because that's the first-
1868 matters, you're telling us. So what was the answer?
The 1868 sources talk about parental. I'm not aware of them drawing a distinction between mother or father, but they say the domicile of the child follows the domicile of the parents.
And how are we going to determine domicile? I mean, would we use contemporary sources on what qualifies as domicile in a state, or do we look in 1868?
This is
And we have to
Justice
do this for every
Gorsuch.
single person.
And again, I don't see a strong distinction between those because, of course, domicile is a high-level concept, has been pretty consistent over centuries, which is lawful presence with the intent to remain permanently. That domicile, when you come to a new nation, you say, I'm here to stay, you become part of their political community, and you become akin to a citizen. And that's reflected very strongly in the case I cited before.
And just to circle back to Justice Kagan's point.
Then why are they
it's striking
deporting
that
people
in
seeking
none of the
asylum
debates
here?
Do we have parents discussed? We have the child's.
Because they're trying to stay,
citizenship.
right? They've made an
And the
intention
focus
to
of the
stay.
clause is on the child, not on the parents. And you don't see domicile mentioned in the debates. The absence is striking.
I think the 19th century sources would say a newborn child.
This is why I
lacks the
say
capacity
this
to
every
form a
time.
domicile, so
Gorsuch
they're
can
imputed the
surprise
domicile of their
you.
parents.
So
I
can
don't think they would
Kavanaugh
have
and
seen
Barrett.
a distinction between children and parents. And I point out that their position, like ours, is forced to look at the domicile of the parents because if you look at the exceptions that they accept, like
I'm talking about
tribal Indians and so
I'm
forth.
talking about in the debates over the 14th Amendment and the Civil Rights Act. It's striking that these concepts aren't discussed in them.
I think domicile is discussed. I mean, it's brought up in many.
Allegiance, jurisdiction, complete jurisdiction.
Not in the debates.
Well, I mean, here's just a few examples. Page 1679 of the congressional record, President Johnson vetoes the first version of the Civil Rights Act. and says,
If you want to
I can't
join
sign this
Law's
because it would extend
Discord,
alien-
just DM me.
citizenship
I
to the
can,
children of, quote, all domiciled aliens
I can
and
send
foreigners,
you a link.
even
I
if
guess
not
it's
naturalized.
expired.
We have all the other sources we cited that say,
Oh.
and this is a
have to fix
deeply
that.
rooted 19th century understanding. It's
may
reflected
just
in the
be on
Venus, it's
my
reflected
end.
in the Pizarro in 1814 and 1817. It carries through the 19th century, and this court is talking about it in 1892 and 1893 when it's discussing the Chinese.
I think the
exclusion
one in
acts.
your profile
Domicile
works.
is the
That's
key
weird.
concept that creates allegiance. That's
General,
General,
so
you said in your reply brief that the children of slaves who were brought here
Barrett.
unlawfully, in defiance of laws forbidding the slave trade, would in fact be citizens. And we can imagine that their parents were not only brought here in violation of United States law, but were here against their will, and so maybe felt allegiance to the countries where they were from. And you say that the purpose of the 14th Amendment was to put all slaves on equal footing, newly freed slaves on equal footing, and so they would be citizens. But that's not textual. So how do you get there? You say it in just a few sentences, so can you elaborate?
Sure. If you look at I think if you look at the 19th century sources, what you see is that even though their entry may have been unlawful, 19th century antebellum law never treated their presence as unlawful. In fact, quite the opposite. One of the amici, in fact, points to like a Mississippi statute, which probably is replicated throughout the South before the Civil War, that says slaves in Mississippi have an indefeasible domicile in Mississippi. In other words, even if they run away, if they get away, Mississippi says, nope, you still live here. right? And so it would be astonishing, in other words, for the opponents of the 14th Amendment to say, oh, you know, these people were not domiciled and therefore it goes the other way, because actually U.S. law, even if they were brought in illegally and through an illegal slave trade, once they were there by
Well,
domestic
their
law,
intent is to return as soon as they can, let's say. So they're here, they're resident, and maybe under your theory, I mean, which says, well, lawfulness for a different purpose, but they're here, they're resident, let's take your assumption that they're not here unlawfully. But let's say they don't have an intent to stay. They want to escape and go back the second they can. Are they domiciled?
Under the 19th century law, I mean, I think this is the flip side of the hypothetical that we were talking about earlier. Under 19th century law, they are treated as domiciled in the United States, so it'd be astonishing. And the debates in the congressional floor talk about not this specific case, but to say, look, slaves who have been forced to come here and have been here are lawfully domiciled here. I mean, they don't use the ways domiciled like they use allegiance. They say they don't have allegiance to, once they've been forced to come here, they don't have allegiance to any foreign or African potentate, and therefore they're.
But General, that goes
How
to
would that apply to the children of illegally trafficked people today? Would the same reasoning apply?
It would turn on whether the parents are lawfully domiciled in the United States.
So if they're brought in illegally,
how do you
but then they
differentiate?
choose to remain and they want to remain and they're domiciled, you would say that their lawful presence is not dictated by whether they were brought here lawfully or not. And that's different from someone who, say, crosses the border unlawfully.
Yeah, I think it would turn on whether their presence is lawful.
General,
in other words, obviously there may be many other important things that could be done to assist people like that. The question is, if they give birth to someone in the United States, that person naturally a citizen, that would turn, based on the original public meaning of the clause, on the lawfulness of their presence. Are they domiciled?
General, can I ask you a question? To follow up on what Justice Gorsuch was explaining to you with respect to domicile, did I understand you to say that domicile is going to be eventually or is controlled by Congress? Who is domiciled? I'm struggling to figure out who is domiciled in your argument.
The domiciliaries are people who are lawfully present and have an intent to remain permanently. So that's a kind of black letter, understanding of domicile.
So real
now,
quick, aren't they deporting people that are showing up at their asylum hearings? I'm confused now.
To form a legally
At least detaining,
If
yes.
that's so, then doesn't it make the domicile for the purpose of the 14th Amendment turn then ultimately on Congress's will in a way that the framers did not intend? I mean, my understanding was the framers put this citizenship clause into the Constitution to prevent future Congresses from being able to affect citizenship in this way.
Sure.
Very briefly, no, I don't think so, because it is up to the alien whether or not they want to be domiciled here. Now, there may be collateral
I thought you just said Congress can make determinations as to who counts as being domiciled here.
Yeah,
so if that's true, then it ultimately would impact, in your theory, whether or not this person can claim that they have citizenship for 14th Amendment purposes based on Congress's determination. And I just thought that's what the 14th Amendment was trying to get away from.
If I may.
Yes, please.
Very briefly, I just point you to the discussion in Professor Werman's amicus brief where he talks about this is not a new problem. Going back even to the British common law, there's a situation of people who lack a safe conduct and are passing through the king's domains without permission. And he says the best reading of the common law is they are not under the protection of the king and they're not covered by the rule of birthright citizenship.
Thank you, Counsel.
I know Professor Werman. He's a
You mentioned
douche.
in your briefing and also this
I'm
morning.
familiar with
problem
him.
of,
Was he that
tourism.
one guy?
Do you have any information about?
Yes,
how
who stole
common
my
that
work.
is, or
Yep.
Yeah,
a
okay.
significant
Yeah,
problem
the
it
name
is?
was.
It's a great question. No one knows for
It's
sure.
okay, I
There's a
became
March
his
9th
professional
letter from a
troll.
number of members of Congress to DHS saying, do we have any information about this? The media reports indicate estimates could be over 1 million or 1.5 million from the People's Republic of China alone. The congressional report that we cite in our brief talks about certain hotspots like Russian elites coming to Miami through these birth tourism companies. And I mean, here's a fact about it that I think is striking. Media reported as early as 2015 that based on Chinese media reports, there are 500 birth tourism companies in the People's Republic of China whose business is to bring people here to give birth and return to
So
that
because
nation.
other people
Having
do
said all
bad
that,
things.
you do agree that that has no impact on the legal analysis?
It's also
before us?
illegal.
I think it's, I'd quote what Justice Scalia said in his Hamdan dissent, where their interpretation
quoting
has
a
these
dissent?
implications that could not possibly have been approved by the 19th century framers of this amendment. I think that shows that they've made a mess. Their interpretation has made a mess of the provision.
Well, it certainly wasn't a problem in the 19th century.
This is Roberts, correct?
No, but of course, we're in a new world now, as Justice Alito pointed out.
Yes.
There were 8 billion people on one plane.
I love how he
away
said,
from
you know
having
that
a
it
child
has
who's a
no
US
Well,
meaning,
citizen.
right?
the
Well, it's a
last
new
question
world. It's
was
the same
Alito. The one before
Constitution.
that was Roberts.
I got you.
It is, and as Justice Scalia said, I think in the case that Justice Alito was referring to, you've got a constitutional provision that addresses certain evils, and it should be extended to reasonably comparable evils. He said that about statutory interpretation. I think the same principle applies here, and I think we quote that in our brief.
Thank you. Justice Thomas, anything further?
General, you're getting a lot of questions about immigration, and they harken back, of course, to the citizenship, which is defined in or set out in the 14th Amendment. How much of the debates around the 14th Amendment had anything to do with immigration?
I think that the principal focus of those debates it
How
has
the
to do really
fuck
not
does
with
that
immigrants,
matter?
but with the Indian tribes. I mean, obviously, the main goal, the one pervading purpose, as this court said in the slaughterhouse cases, was to establish the citizenship
Love
of the
that
freed slaves
this
and their
is the
children.
case they're
But they were
pulling.
very concerned about the
Cases.
problem of something that they all accepted as a given, which is that the children of tribal Indians are not within the rule of birthright citizenship. So I think that's what they focus on. We draw an analogy to that, to
Absolutely
the issue
not,
of temporary
Michael.
sojourners. And then, but
That's
there are
mean.
mentions of temporary sojourning multiple places in the congressional debates, and all of those quotes go in our direction.
And there was, Justice Sotomayor brought up Wong King Ark. There was no question in that
Not the
case
Wong
that,
King arc.
about domicile, was there?
I disagree. The court says at the very beginning of its opinion, here are the accepted facts. These are lawfully domiciled here. When it states the question presented, it talks about domicile. When it recites the legal principle at page 693, it says domicile 3 times.
Hey, Attorney
And at
Dye,
page
you can
705,
come up whenever
the
you're
opinion
ready.
says, here's the single question we've decided. We've decided that Chinese immigrants with a permanent domicile and residence here fall within the rule of birthright citizenship.
Justice Alito?
Under the minimum definition of domicile, which I think existed in 1868 and continues to exist today, a person's domicile is the place where he or she intends to make a permanent home. Now, normally, you would think that a person who is subject to arrest at any time and removal could not establish a domicile. But we have an unusual situation here because our immigration laws have been
Homeless people get arrested all the time. Should we
and
deport
in
them
some
too?
instances unenthusiastically.
It wasn't a
enforced.
slight at homeless people.
by
by the way.
federal
Just this
officials.
dog shit argument.
So there are people who are subject to removal at any time if they are apprehended and they go through the proper procedures. But they have, in their minds, made a permanent home here and have established roots. And that raises a humanitarian problem. And I wonder if you could address that.
If I may, one legal and one humanitarian. The legal point is, if you look at those cases, for example, Carson against Reed, Park against Barr, this court's decisions in Elkins and Toll against Marino, they talk about the legal capacity to create a domicile, excluding someone who may have the subjective intent, which otherwise would be determinative, as being excluded. On the humanitarian point, I would point out, as I said at the beginning, Justice Alito, that the United States rule of nearly unrestricted birthright citizenship is an outlier among modern nations. It's a very small minority of nations that have that rule.
It still
For
doesn't
example,
matter. Are we
every
appealing
nation
to
in
majority
Europe
now?
has a different rule. And the notion that they have a huge humanitarian crisis as a result of not having unrestricted birthright citizenship, I don't think is a strong argument. And I point out, obviously,
He would not make that argument about the Second Amendment.
Exactly.
Reasons, this
That
executive
part.
order applies only prospectively, and we ask the court to rule only prospectively.
Justice Sotomayor?
I agree with you what the European nation's rule is, But England was always different, wasn't it?
Not until 1983 it changed to the
That's not quite true. The Wong Kim Ark does a wonderful job of laying out the English rule. And you claim it was different, but there isn't any treatises or scholars who say it's different. English rule was always by birth. Other countries were not by birth. Let me just go to the implications of what you're asking us to do.
Grant,
You
no,
are
but we
asking
draw
us
from
to
English common
overrule
law
Wong
and
Kim
other
Ark?
things like that.
Well, Wong Kim Ark's parents were domiciled in the U.S., but they owed loyalty to China. They eventually returned to China. So they didn't have a primary allegiance to the United States.
Amen.
So you're not asking that. Are you asking us to overrule, then, our cases, one of which said that a child of illegal aliens was a citizen? You're asking us to overrule that.
No, first of all, we're not asking you to overrule Wong Kim Ark. We agree
you
with the
are
holding of
asking
Wong
us
Kim Ark
to-
and much of the reasoning. And then as to those later cases starting in 1966, where the court makes sort of, unreasoned references to this
Wait a
issue,
minute.
we think
Him top you loose. The respondent unlawfully overstayed her visa and gave birth to a child here. The court, Harlan II, wrote, "The child is, of course, an American citizen." That person wasn't domiciled here lawfully. So you're asking us to overrule that case?
I wouldn't say we're asking you to overrule. We think that's similar to a drive-by jurisdictional ruling where there's a simple statement that's not debated. There's no further analysis of it. There's really an assumption there. And we think that's similar to cases where the court just assumes jurisdiction without discussing it.
When we ruled in Trind that Indians could not become citizens, the government then after began to unnaturalize many Indians who had been sworn in as citizens. You asked us to concentrate only on the prospective nature of the citizen's order. But the logic of your position, if accepted, is that this president or the next president or a Congress or someone else could decide that it shouldn't be prospective. There would be nothing limiting that, according to your theory.
If, as we asked, the court confines its ruling to prospective relief only, which it did in
No, I'm
Sessions
saying
against.
to you, that's what you're asking us
This
to
is
do.
Justice.
Now,
Yeah,
I'm
Sotomayor.
asking whether the logic of your theory would permit what happened after the court's decision in Trin, that the government could move to unnaturalize people who were born here of illegal residents.
They could, and they
No,
will.
we believe the court should do what it did in Sessions against Morales-Santana, where there was a ruling that would have deprived people who are already citizens of citizenship, and the court said this applies prospectively only, and we think that's the appropriate course here.
But that's not what we did in Trin.
We think that Sessions provides the proper course here, and that's what we're asking. We are not asking for any retroactive relief.
Justice Kagan?
General, I think even your brief concedes that the position you're taking now is a revisionist one with respect to a substantial part of
Susan,
our
we're about
history.
30 minutes in.
And I think that that's in large part because of Wong Kim Ark and the way people have read that case, which of course was in the late 19th century, and have read it ever since then. And what that case suggests is, there's a very clear rationale. You say, it says the word domicile a bunch of times, which it does. It's a long opinion. It says a lot of things. But the rationale of the case is really quite clear. It says there was this common law tradition. It came from England. We know what it was. Everybody got citizenship by birth, except for a few discrete categories, which were the ones that the Chief Justice mentioned at the beginning. And that tradition carried over to the United States. And then what the 14th Amendment did was accept that tradition and not attempt to place any limitations on it. And so that was the clear rationale, a clear rationale that is diametrically different from your rationale. And everybody took Wong Kim Ark to say that and to say that as a result of that, of course, birthright citizenship was the rule. And I think everybody has believed that for a long, long time. And I guess my question is this. You have a story about the reasons why we should go back to what you view as the original meaning. And given the long history of this country's understanding about birthright citizenship, what would it take, what do you think it should take to accept that story in terms of the magnitude of the evidence that we would need to see in order to accept this revisionist theory and in order to change what I think people have thought the rule was for more than a century?
Let me make 2 points in response to that, one historical and one legal. Historical point, I disagree with the way you've characterized the understanding of Wong Kim Ark, and I would point to something that's emphasized in their amici's briefs, which is in 1921, Richard Flournoy, who becomes a senior State Department official in the Roosevelt administration and pushes their theory as to temporary sojourners, writes a law review article in 1921 where he says, I think that children of temporary visitors should be citizens. But he admits
they're
that is not
reaching
the
into
understanding
the
of Wong Kim Ark.
depths
He admits
to
Wong Kim
pull
Ark did
this
not
shit.
hold that. And he admits that there's an array of authorities that go against him. He talks about careful and reliable, high authorities. And that's referring to the consensus that we point out in pages 26, 28 of our brief. We've got 12 treatises from 1881 to 1922 that all say, including for decades after Wong Kim Ark, that say children of temporary sojourners
Out
are
of
not
curiosity,
included.
does
What happens
anybody
between
know
1921 and the
when he wrote
1930s?
this
Well,
law
Mr.
review
Flournoy
article,
became a senior
was it
State
from the
Department official. He
perspective of the
adopted that as the
Roosevelt
policy
administration
of the Roosevelt
or his
administration.
own
So their argument
perspective?
is basically saying there
So they're
wasn't
two
this
different
consensus
things.
going back to
I'm not sure, but I don't
the
think they could
consensus
drink
is
any
their author
alcohol.
admits goes entirely in the opposite direction. For 50 years, right, for 50 years from the framing of the clause through the 1920s, maybe 60 years, the general understanding when it comes to what's at issue here and was not at issue in Wong Kim Ark is the children of temporary visitors do not become citizens under the clause. And then the legal point, you referred to the sort of concept of temporary local allegiance.
But how are
and
we
they rely on
determining
the
a
student
temporary
exchanges theory
visitor?
that you've got temporary local allegiance. But if you actually look at page 572 of the congressional record, right at the beginning, introducing the Civil Rights Act, Senator Trumbull says, I said not subject to any foreign power. I wanted to say born in the United States and owing allegiance to the United States, but I was aware that there's a, quote, a sort of allegiance from persons temporarily resident in the United States whom we have no right to make citizens. So Senator Trumbull says the reason I haven't adopted
He was talking about Native
They say
Americans.
should be packed into these provisions.
Yeah, I was gonna
is
say.
that everybody knows that the children of temporary visitors should not be citizens.
Thank you, General.
Justice Gorsuch?
Just to follow up on that point, General, one interesting counterpoint about the understanding of Wong Kim Ark that followed with respect to temporary sojourners. And I take you've got your well-taken points. But there was, of course, John Marshall Harlan, the great dissenter, who dissented in Wong Kim Ark and later gave a bunch of lectures. And he posed the question about the sojourners. Suppose an English father and mother went down to the hot springs to get rid of the gout. And while there, they have a child, now back in England. Is that child a citizen of the United States, born of the jurisdiction thereof by mere accident of birth? And he says, under Wong Kim Ark, he is. And he continues, I was one of the minority, and of course I was wrong. Now, I'm sure that was tongue-in-cheek, but now, what do you do with that?
I'd say two things in response to that. First of all, he gave a speech, but we have 12 uncontradicted treatises that say the opposite, that is not what Wong Kim Ark means, and that's not the meaning of the clause. But also, I make a more fundamental point. When you're looking at Wong Kim Ark, one of the dissent has this dominant theme that like you can't be doing this because you can't make we all agree, or it's obvious that the children of temporary visitors do not become citizens. And how does the majority opinion address that? It says domicile 3 times when it recites the legal rule. It says permanent residence and domicile when it decides the holding.
Is he yelling at Gorsuch? That's not going to go well.
It says this is what we're deciding. And again, on page 75, it says this is
I
the
love it
single
when
question.
Gorsuch gets mad. It's like my crack.
But at the very end, they said the single question we've decided is
I just enjoy it so much.
The children of Chinese immigrants with a permanent residence and domicile in the United States.
Do you think Native Americans today are birthright citizens under your test and under your friend's test?
I think so. I mean, obviously, they've been granted citizenship by
Put
statute.
aside the
I
statute.
think
they're
so.
birthright citizens.
He doesn't
No,
know.
I think the clear understanding that everybody agrees in the congressional debates is that the children of tribal Indians are not birthright
I
citizens.
understand that's what they said, but your test is the domicile of the parents, and that would be the test you'd have us apply today, right?
Yes, yes. So if a tribal Indian, for example,
Are tribal
gives up
members
allegiance to,
born today, birthright citizens.
I think so on our test. Yeah, if they're lawfully domiciled here.
Okay,
I'm not sure. I have to think that through, but
I'll
that's my reaction.
I'll take the yes. That's all right. I just want to ask you quickly about the INA, adopted in 1940 and 1952. It uses the same term as the Citizenship Clause, and one might have a pretty good argument. I'm sure you got some arguments along just these lines that it should be understood to mean whatever it meant in 1868. But there was a lot of water over the dam between those two things. And as your brief points out, by the Roosevelt administration, there's a pretty strong jus soli move. That is to say that the thin concept of jurisdiction, power over, is enough, a broader understanding of birthright.
It's
Would there be
jus
an argument
soli.
for reading that statute under its original
Right by
plain
birth.
meaning at the time, 1940, 1952?
Right of the soil.
Perhaps have a
Yeah.
different meaning than the Constitution.
And then there's,
We don't think that's
what
the
is
best
it, jus
interpretation.
sanguinis,
Give
which is
two
right by
reasons. One
blood?
is it would be very surprising
Sorry.
if
Correct.
a statute that says exactly the constitutional phrase subject to the jurisdiction thereof were interpreted to mean something totally different or to ossify a then current misunderstanding of the clause. We think that the best analogy here is probably state long-arm statutes. Take a sort of non-controversial example. State long-arm statutes routinely say we're going to exercise personal jurisdiction to the extent of due process. It takes the constitutional standard and it puts it in the statute, and nobody thinks that those ossify,
I don't think Gorsuch is vibing this, which makes me feel a little bit more comfortable. I can't say for certain. I got to see the next argument, but yeah.
Developing law of due process,
Agreed.
minimum contacts, and so forth.
If it's got something to do with indigenous
that's the best
peoples,
analogy when
he's
when you're
definitely
looking at the constitutional phrase itself,
leaning one
you take
way.
it out of a freighted
I think he has a
context,
healthy
the
level of
natural interpretation
skepticism
is that
here.
This means this reflects the objective meaning of
Agreed.
the Constitution, and the objective meaning of the Constitution is its original public meaning in
I
1866.
haven't gotten a read on Barrett yet, but
Notable counterpoints to that argument.
I'm sure
Kavanaugh,
there are
I don't think
arguments on
I've
the other
heard
side.
him.
We addressed them in their brief.
So you're really, at the end of the day, then, this is a straight-up constitutional ruling you want from this court, win, lose, or draw.
Yeah, we think that the statute and the Constitution means the same thing. If the court disagrees, obviously we prefer an adverse ruling if the court's going to do that on a statutory basis than a constitutional basis.
But you just disavowed that in your responses to me by saying that that's not an available option, is the way I understood it.
Yes, the court would have to disagree with our statutory position, which is that it means the same thing as the Constitution. But if the court were to do that, then the natural course would probably be to rule on statutory grounds alone. Now, we think they mean the same thing, and we've got arguments for that, including, I think, the analogy I just referenced.
Thank you.
Justice Kavanaugh?
General, how should we think about the text of the 14th Amendment, subject to the jurisdiction thereof, as distinct from the different language of the Civil Rights Act of 1866, which refers, as you know, to persons not subject to any foreign power? Those texts are, on their face, different, and the history that Justice Kagan referred to might have developed quite a bit differently if the 14th Amendment's text had used the phrase that was in the Civil Rights Act.
That's an excellent point, and this court has held in multiple cases, Hurd against Hodge and General Building Contractors, has recognized that they were intended and they did mean the same thing, and that's powerfully reinforced by the congressional debates, where really what they're discussing is they said they were dissatisfied with the language in the Civil Rights Act because the phrase Indians not taxed they thought was ambiguous. And so they switched to the affirmative statement as opposed to the negative statement. The affirmative statement is subject to the jurisdiction thereof, but there's express statements in the congressional record essentially that we're doing the same thing, and that is what this court's case law has reflected.
Why didn't they say the same thing?
Again,
Matthew, his name is
appears
John
they preferred the
Sauer,
sort of
and yes, he
positive
sounds like
formulation, subject to
RFK.
jurisdiction thereof, as opposed to not subject to any foreign power. And again, there's a deep concern and lengthy discussion of the potential ambiguity in the Civil Rights Act thing. They want to eliminate an ambiguity, but do the same thing. And I think that that's very strongly reflected in those debates.
By the time of the 1940 and 1952 congressional actions, where Congress repeats subject to the jurisdiction thereof, given Juan Kim Ark, one might have expected Congress to use a different phrase if it wanted to try to disagree with Wong Kim Ark on what the scope of birthright citizenship or the scope of citizenship should be. And yet Congress repeats that same language knowing what the interpretation had been. So how are we to think about that?
I think baked into that question is an understanding, I think that was reflected in Justice Kagan's earlier question, that everybody understood that Wong Kim Ark meant that, and the history I talked about, I think, refutes that. That really there's a consensus that goes our way for decades and decades after the adoption of the amendment and after Wong Kim Ark on the specific question of the children of temporary visitors. And it's really not until, and again, and their author in 1921 is saying, hey, the other side is the consensus.
I'm sorry.
Yeah, sorry, go ahead.
But there's executive branch interpretations and others. And if you're in Congress in 1940 and 1952 and you want to limit the scope of Wong Kim Ark or to eliminate ambiguity, why do you repeat the same language rather than
That's a good
choosing
question.
something different? For example, you could use the language from the Civil Rights Act of 1866 or some similar formulation if your idea in 1940 and 1952 was to not have ambiguity or not have an overly broad scope.
I think
Can you talk about the tomato case?
Look at the structure of that statute where it's 1401A and then B through H.
Not
A,
sure.
it says these are the people who are entitled to birthright citizenship. A is the constitutional standard, and then B through H are all the categories that Congress has superadded to that. I think the natural inference is that Congress is codifying, which it was consciously doing in 1941, pulling all the naturalization rules and immigration rules together into one statute and said, you go to one place, here's who is a birthright citizen. A, those who are guaranteed that right by the Citizenship Clause, and B through H are the ones that Congress has added through its naturalization power. So that inference to me says A is merely, it's not trying to change or alter the constitutional standard, it's just saying, hey, the baseline is what the Constitution says, and we codify that, and then we move on to the new categories.
Of what relevance, if any, do you think Section 5 of the 14th Amendment has here that gives Congress the power to enforce the article, the 14th Amendment, by appropriate legislation? Does that give Congress room here, or do you not think so?
I do think that a ruling in our favor would leave room for Congress. I don't think you'd have to rely on Section 5. I think that Congress has its own inherent power to grant citizenship by statute. So if the court were to rule in our favor for the classes of individuals that they say should be covered, Congress has the latitude to do that.
How much room do you think Section 5 gives, if any, and it may not be any, Congress to interpret the phrase subject to the jurisdiction thereof or to define that? Is that relevant at all?
It's a great question, and I'm thinking about it for the first time. I assume it would be governed by the congruence and proportionality test from this court's
Thinking
case
about
law.
it for
How
the
that would apply
first
here, I
time?
don't know. And I don't think it's presented because our contention is that the statute means exactly the same thing. If anything is congruent and proportional, it's that. And I think the court held that in the United States against Georgia.
You've mentioned several times the practices of other countries, and that's obviously, as a policy matter, supports what you're arguing here, but obviously we try to interpret American law with American precedent based on American history. That's certainly what I try to do, and I think
Well,
you
now
try
I
to
want
do.
universal
So
health care if we're going
why
off
should
of
we
other
be
countries'
thinking about,
laws.
even though as a policy matter I get the point, thinking about, gee, European countries don't have this, or most other countries, many other countries in the world don't have this, doesn't that, I guess I'm not seeing the relevance as a legal, constitutional, interpretive matter necessarily, although I understand it's a very good point as a policy matter.
Yeah, I largely agree with that, and you can view it as being raised preemptively, defensively. I'm going first, but obviously the other side in their amici say, make it prediction, end of the world type predictions, and our point is, it's a very small minority of countries. Almost every country, and certainly all European countries, have a different rule, and the world hasn't ended there.
The other side, last one, the other side relies heavily, of course, on Wong Kim Ark, and you disagree with their interpretation. Oftentimes, when you are dealing with a constitutional precedent like this, you might argue, we disagree with that interpretation, but if you adopt their interpretation or agree with their interpretation of that precedent, you should overrule it. And you haven't made that argument here, and I'm just giving you an opportunity to explain why you haven't.
Because we think it's totally unambiguous in Wong Kim Ark that the holding is relates to domiciled aliens. And so we
What?
strongly agree with
God.
we think domicile was the touchstone, and we think that's not a coincidence for the reason I maybe speculate a little bit.
I
when was
fucking
talking to
hate it
Justice
here.
Gorsuch about how the dissent raises this, and then the majority's like, we're putting domicile in there.
I
so we
think
know
we're
that the
just
absurd
making
conclusion
shit
that
up
they
at
say
this
would
point.
come from this isn't there. But also domicile as kind of the sort of relationship that creates this relationship of allegiance that makes you part of a political community if you're an alien from another country. That's deeply rooted in their understanding when they do it.
Oh,
They
hey,
talk about
Ari, good
domicile
morning.
Gitmo against Hopkins in the 1892 and 1893 cases, and there's this deeply rooted understanding, again, that goes all the way back to the early 19th century. So we think that's a really important conception. So I mean, we disagree with some of the dicta in Wong Kim Ark that we discuss, and we think there's dicta that goes our way that the other side overlooks. And we're not asking the court to overrule dicta. We just say don't follow erroneous dicta and don't apply it to this brand new situation that was not decided in Wong Kim Ark.
Thank you.
Are they having a dicta
General Tsai, I
measuring
wanna zoom out
contest?
a little bit
Sorry.
and think about jus soli and jus
stole my
sanguinis.
joke.
So as I understand it, at the time of the 14th Amendment, those were the two
You know,
dominant
Wong
approaches.
Kim Ark,
You know, jus
although
soli,
a
the English
hero,
common law,
actually
roughly
never was
following
able
the
to
soil.
utilize his
Jus
citizenship.
sanguinis, roughly citizenship.
He had to stay on
following
a
the
ship in the
parents.
harbor.
Now, jus soli was very generous on the soil, the English common law, and so it extended citizenship to those born there who may not have been born of parent citizens. But jus sanguinis, if parents who were citizens and had a child abroad, then that child's citizenship followed the parents. So one thing that's puzzling me about your argument when I think about the ratification of the 14th Amendment, in many ways it would have made sense for them, and you acknowledge the jus sanguinis in citing Vattel. It would have made sense in some ways for them to say,
It's an
okay, we're gonna
erroneous
follow,
dicta
if they
is
wanted
the
to
worst,
accomplish
y'all.
what you're saying they wanted to accomplish. You could say, well, we're going to follow jus sanguinis because we're going to make it all right on parentage. But instead, I mean, the 14th Amendment, we're talking about subject to the jurisdiction thereof, but it also says born in the United States. So you have the jus soli kind of point there, but you're saying it narrowed that point by tying it to the citizenship of the parents, at least as to soil. But I take it you're not arguing that United States citizens who have children born abroad would qualify for birthright citizenship. So it's kind of a narrower view of both the traditional jus soli rule and a narrower view of the jus sanguinis rule. So why would they have done that? And if they were going to invent an entirely new kind of citizenship, like an American brand, why wouldn't we have seen more discussion of that in the debates?
Barrett's getting a little bit of an attitude.
I think the right way to
I love it.
conceptualize it is much more, it is a modified use.
Can kind of hear
It's
it
a
in her
super
voice.
nerdy
Even the
question,
British
and I
sources
love
don't
it.
just say you're a citizen. They say you're born here and you have to be under the protection of the sovereign. You have to have a relationship of allegiance. Allegiance is the word in Calvin's case.
But
It's
they don't
brought in
focus on the
Blackstone.
parents, it's the child. And your approach focuses on the parents' allegiance.
Yeah, I'm not sure that that's true of the 19th
It seems a
century
little
sources,
ambiguous,
but
and I'm going to ask your friend on the other
How
side
could
that
an
question.
infant
let
have
me
allegiance to
point out then that there are
anything?
two criteria.
Why do you say
One
I'm
is
not
birth
sure
on the
so
soil,
much?
And the other is allegiance or allegiance. What we have is birth on the soil remains
he
the same,
pulled this
right?
stuff out of
And
his
so they
ass?
are, and that's why so much of Wong Kim Ark is actually
Swear to
we
God.
agree with, because they are adopting a modified British rule. They are not going the French rule, that Vattel talks about, where it's like who's the citizen. That had to be done by statute, as you pointed out, which it was in 1401. But what they've got is they say birth in the United States and subject to the jurisdiction thereof. That is talked about as allegiance, allegiance, allegiance in the congressional debates. But they were clearly not incorporating the British feudal monarchical conception of allegiance where it's indefeasible. I mean, going back to the early 1700s, our nation had repudiated the notion that citizenship is indefeasible. The expatriation statutes from the late 1700s reflect that. And again, you look at the 1868 congressional report that we cite there, this is the same group of congressmen, Republican congressmen, and they say things like the U.S. Constitution itself is proof that Blackstone's theory of
Hey, y'all
allegiance
tap the
was
screen
not
so
accepted.
Ari doesn't
So
turn
they
the
accept
comments off.
birth
I
on US
actually like
soil,
seeing y'all
but
down
then
there.
They take the concept of allegiance and give it its Republican, Democratic, American understanding. And that's very, very, I think that makes a ton of sense.
Okay, and let's talk about its applications. So, there are some, I can imagine it being messy in some applications. So what would you do with what the common law called foundlings? The thing about
love
this
you,
is then you
Goobs.
have to adjudicate. If you're looking at parents, and if you're looking at parents' domicile, then you have to adjudicate both residence and intent to stay. What if you don't know who the parents are?
I think there are marginal cases. That one, I think, has the benefit of being addressed in 1401F, where it talks about.
Yeah. But what about the Constitution?
Under the Constitution, I mean, look, domicile is a
That's my favorite part.
All kinds of other situations.
My favorite part so far.
Diversity, jurisdiction, personal jurisdiction. Sorry.
Well, yeah, and personal jurisdiction.
Barrett not
1332,
vibing,
diversity
Gorsuch
of
not
jurisdiction.
vibing,
And the thing
Roberts,
is, it has to be litigated
I don't
because
think
it turns
he's
on
vibing.
intent.
All the liberal
And
justices not
both
vibing.
the virtue of both jus soli and jus sanguinis, whichever one you pick, it's a bright line rule. How would it work? How would you adjudicate these cases? You're not going to know at the time of birth for some people whether they have the intent to stay or not, including U.S. citizens, by the way. I mean, what if you have someone who is living in Norway with their husband and family, but is still a U.S. citizen, comes home and has her child here and goes back? How do we know whether the child is a U.S. citizen because the parent didn't have an intent to stay?
I'd say make 2 points, one practical, one legal. The practical point is under the terms of this executive order, you don't have to because the executive order turns on objectively verifiable things, which is immigration status. Are you lawfully present but temporarily present, or do you have an illegal status? So those kind of taking evidence, so to speak, under subjective intent.
What about asylum seekers?
Done. And as to the constitutional point, obviously domicile is baked into a lot of constitutional and legal concepts, and there may be situations where facts are determined.
Where does that
but if
one
you look
go?
at the guidance.
There was no such thing as an illegal immigrant in 1868.
That part.
Very, very clear, objective, verifiable approaches to doing this. And so as a practical matter, I don't think it's presented by this executive order.
Thank
That
you,
was
General.
4 years after the
Justice
Civil
Jackson?
War, too.
Good morning, General. So I guess I am looking at your
Justice
position
Jackson.
in this case, and it boils down to requiring us to do at least these two things. One is believe that the framers were not importing the common law rule and understanding of birthright citizenship.
We like that.
And the second is to believe that what they were doing was departing from that common law rule in the way that you suggest. That is, they were seeking to have this turn on domicile. I think you have a number of hurdles to accomplish those two things. One of which, I think, is that when we look
It's like she was
at
reading Law's Twitter
this
posts.
court's case law, and no one, I think, has mentioned Schooner's Exchange, but it appears that that was an 1812 case in which it seems as though the court had already accepted at the time of the ratification of the 14th Amendment that the allegiance that you were talking about was the English common law rule. That, in other words, allegiance meant that you are covered by the laws of the jurisdiction, that you can rely on that jurisdiction's protection. That's what allegiance meant. Now, you're saying today, no, allegiance meant something about loyalty or that kind of idea. But if the Supreme Court had, prior to the 14th Amendment, established that allegiance meant the common law definition, I think your first hurdle is to help us understand why we would believe that when the 14th Amendment was ratified, the framers weren't just incorporating what we had previously said it meant.
Page 572 of the congressional record directly addresses this. They say the concept of temporary and local allegiance from the Schooner Exchange is what is meant by, or temporary and local jurisdiction from the Schooner Exchange is what is meant by the word jurisdiction in the 14th Amendment. Senator Trumbull says, I thought about saying owing allegiance, but again, quote, there's a sort of allegiance from persons temporarily resident in the United States whom we have no right to make citizens. So he expressly and consciously rejected reliance on Schooner.
What do we do with, I mean, that's a debate.
We're going to talk about this debate after. I know Law has read the whole thing.
Between Fessenden and Wade, where the same concept comes up, and it becomes clear, at least from Senator Wade's perspective, that that's wrong. So Fessenden, and I'm not sure whether these are senators, I apologize. Fessenden says, suppose a person is born here of parents from abroad temporarily in this country. Wade responds, the senator says a person may be born here and not be a citizen. I know that is so in one instance, in the case of the children of foreign ministers who reside near the United States, et cetera, et cetera. So it appears as though in that exchange, at least Senator Wade believed that the English common law understanding of what it means to have allegiance, to be a temporary person on the soil.
We're about an hour
was what
into
was being
Sauer's
adopted.
side of the argument.
That exchange strongly supports us. If you look at it in context, Senator Wade has introduced a version that says only birth on U.S. soil and doesn't have any allegiance or jurisdictional element to it. And so Senator Fessenden stands up and says, well, that can't be right because, obviously, what about the children of temporary visitors? It has this, it's another one of these
he was
statements that
talking
has
about
this
Native Americans.
appeal to a background understanding.
Again.
We all agree that the temporary visitors, their children do not become citizens. And then Senator Wade has to kind of backtrack and say, well, what are the children of ambassadors? And in the end, Congress does not adopt Senator Wade's proposal. So we think that to the extent you can draw an inference from that, the inference strongly supports us.
All right, well, let me just ask you about why we wouldn't see in the 14th Amendment anything about parental allegiance. Several of my colleagues have talked about the fact that your view of this turns on what the status of the parents are and not the child, as would the born in the United States view of it. Can you help us understand why we wouldn't expect to see a mention of parents in the text of this amendment?
I think it was well understood that, for example, children cannot, newborns cannot form domicile. So it follows every 19th century.
That assumes
Are you
domicile
sure?
is in the test. And I'm asking you, how do we know that Congress did adopt the test that you say it adopted?
Yeah, when you're looking at 19th century conceptions of allegiance, the notion that the allegiance, again, we say domicile is instantiating the concept of allegiance for aliens as opposed to citizen. All of that, the 19th century understands the newborn's domicile, its allegiance follows the allegiance of the parents. And I point out that their theory relies on parental allegiance as well, because they recognize the exceptions for, hostile invading armies, for tribal Indians, for ambassadors. Again, the child's allegiance status, even on their view, turns on the status of the parent.
What do we do with Professor Mueller's amicus brief and the historical record and the fact that even at times in this country where we understood that the parents were declared enemies of the United States, I'm talking about World War II and Japanese internment, babies born in that circumstance were given birthright citizenship. So it seems as though this concept of allegiance of the parents really wasn't driving birthright citizenship, at least at this period of our history. So are you saying this is wrong, or they shouldn't have gotten birthright citizenship?
Well, if they were domiciled here, yes, they should have. If they were temporarily present, then no. But the executive practice we can see from the 1930s.
How does the temporary presence run with your concept of allegiance? I'm not sure I understand. So can you be clear? Are you saying that only people who are domiciled here, as you define it, can form the necessary loyalty to the United States?
It's not allegiance is not a question of subjective loyalty.
Okay.
Oh, it is something you owe. It's a reciprocal relationship between the citizen, whether they want it or not, they have that allegiance. And I think it's powerfully...
On the basis of what?
Domicile. I mean, that's what it says in so many words in the Venus and the Pizarro. It says, look, if you're talking about an alien, if they're just temporarily passing through, no, they don't have allegiance. But if they've made it their permanent home, they become part of our political community, and they are analogous or akin to citizens.
All right, just quickly,
How are we
because
distinguishing
I'm
allegiance
mindful of
here?
the time.
What qualifies?
What do you do
That's
with
the problem.
Juan Kim Ark's statement that
Can I
birthright
then
citizenship
revoke
is
someone's
applying,
citizenship
quote,
because they are not
independently of a
allegiant
residence
enough?
with intention to
That
continue
would
such
violate the
residence,
Dulles case.
independently of any domiciliation. I know that they use domicile, it's a fact in the case, but that's not a part of their holding. It's not what the reasoning turns on. Correct?
I believe you're quoting from page 693 of that opinion. It goes on to say, not citizen terms on that, but the duty of obedience to our laws. It doesn't take the further step at that point and say, therefore, if you have temporary and local allegiance, you're a citizen. And immediately before that, you have that page 693 summary of the court's holding where it says
You say
domicile.
Juan Kim Ark incorporates a domicile requirement.
That is the holding. It's definitely clearly expressed in the holding.
All
in
right,
multiple
one final
places.
thing, perspective.
But they're the
You
only
say
people who
perspective,
figured
we're
this
supposed
out.
to do
That's
this.
crazy.
Don't worry about the people who are already here and who would not qualify under your rule. How does this work? Are you suggesting that when a baby is born, people have to have documents, present documents? Is this happening in the delivery room? How are we determining when or whether a newborn child is a citizen of the United States under your rule.
And I think that's directly addressed in the SSA guidance that's cited in our brief. What SSA says is there's currently a system where, for example, Social Security numbers are generated based on the birth certificate. They say this can still be, for the vast majority of instances, completely transparent. You will still get a...
No, not transparent. I'm just talking about the particulars, because now you say your rule turns on whether the person intended to stay in the United States. And I think Justice Barrett brought this up. So are we bringing pregnant women in for depositions? What are we doing to figure this out?
No, as I pointed out earlier, the executive order turns on lawfulness of status. So
Oh my gosh.
if you give birth to a
How
baby in
are
the hospital
you
right now,
establishing
it gets
it?
the birth certificate
Jesus.
in the system. There's a computer system.
So there's no opportunity, there's apparently no opportunity then for the person to prove or to say that they actually intended to stay in the United States.
Absolutely not. The opposite is true. Their opportunity to dispute if they think they were wrongly denied, which would only happen in a tiny minority of cases,
After the
is
fact.
directly addressed in that guidance.
After the fact.
Just for
after
clarity,
their baby has been denied citizenship.
When I
then
had
we can
my
go through the
last
process.
child, I
And
went
the
to
way
the
that- I'm
hospital, I
summarizing 'cause I'm not an
pre-registered.
expert in
I was
computers,
only
but there's a
asked for
computer
my
program
ID
that
and
currently
health
automatically
insurance.
generates a Social
My
Security
ID
number.
does not
SSA
denote
says
my
it's not a Social Security
citizenship.
number. Non-citizens can have them if they have work authorization, so it doesn't prove citizenship.
No,
We'll
no
give you a
allegiance
Social
to the
Security
United
number,
States
provided
clause.
that there's the system automatically checks
Well,
the immigration
nothing
status of
like
the
that.
parents, which there are
They
robust
didn't ask
databases
me,
for,
did I pledge
and then
allegiance to the flag or
It
anything.
appears no different to the vast majority of birthing parents.
Thank you.
They just demanded it
Thank you,
mid
counsel.
C-section. I was awake for both of mine spinal blocks, so
Oh.
they made me say pledge allegiance to the flag, you know?
Mr. Chief Justice, and may it please the court, ask any American what our citizenship rule is, and they'll tell you, everyone born here is a citizen alike. That rule was enshrined in the 14th Amendment to put it out of the reach of any
The
government
ACLU
official
is
to
making the
destroy.
argument for this.
When the government tried to strip Mr. Wong Kim Ark's citizenship on largely the same grounds they raised today, this court said no. 30 years after ratification, this court held that the 14th Amendment embodies the English common law rule. Virtually everyone born on U.S. soil is subject to its jurisdiction and is a citizen. It excludes only those cloaked with a fiction of extraterritoriality because they are subject to another sovereign's jurisdiction, even when they're in the United States. A closed set of exceptions to an otherwise
It's talking about like
universal
foreign
rule.
diplomats and
My friend has now
few
clearly
different cases.
said that the government is not asking you to overrule Wong Kim Ark. That is a fatal concession, because Wong Kim Ark's controlling rule of decision precludes their parental domicile requirement. The dissent understood that, and the majority tells us 6 times in the opinion that domicile is irrelevant under common law. Lynch
Dead
versus
ass.
Clark was already the dominant American case on citizenship, and it held that the US-born daughter of temporary visitors from Ireland who took the baby back to Ireland with them, that daughter was a US citizen. Authorities, including Lincoln's Attorney General and Kent's commentaries, embraced Lynch, and Kent specifically talked about temporary sojourners' children being US citizens. Justice Field said in 1884 that that reflected the general understanding. That understanding was confirmed by Congress with its 1940 Act. The 14th Amendment's fixed, bright-line rule has contributed to the growth and thriving of our nation. It comes from text and history. It is workable, and it prevents manipulation. The executive order fails on all those counts. Swaths of American laws would be rendered senseless. Thousands of American babies will immediately lose their citizenship. And if you credit the government's theory, the citizenship of millions of Americans, past, present, and future, could be called into question. All of this tells us the government's theory is wrong. I welcome the court's questions.
She was
There
cooking.
are 5 exceptions
Ms. Thomas?
To citizenship that you do accept.
Yes, depending on how
Hey,
many
Law,
you count,
I'm
Justice
just going to
Thomas,
take a
how
quick
you count
bathroom
them.
break. You got this for a sec?
What is the underlying rule of law that you use to connect these 5 exceptions?
We got you.
Sure.
Okay,
so,
thank you.
as I just said, all of the exceptions involve situations
I
where
got
that
you, sorry.
U.S.-born child
Come on,
is not
Law.
subject to the jurisdiction of the United States because that extraterritoriality, that fiction of extraterritoriality, the interaction of another sovereign between the United States' jurisdiction and that person applies to the child as well as to the parent. Everyone else born in the United States is subject to the United States' jurisdiction. To answer Justice Barrett's question to my friend, that's what sets those exceptions apart from other U.S.-born persons.
We've heard a lot of talk about Wong Kim Ark, and you dismiss the use of the word domicile in it. It appears in the opinion 20 different times, and including in the question presented and in the actual legal holding. And the government doesn't want it to be overruled because it's willing to rely on that particular fact in that case. Isn't it at least something to be concerned about, to say that since it's discussed 20 different times and has that significant role in the opinion, that you can just dismiss it as irrelevant?
Well, Mr. Chief
Justice, Roberts.
I think we have to look at what the controlling rule of decision is in Wong Kim Ark. Justice Gray takes pains in the majority opinion to set out his analysis. He first starts with a premise that in construing the 14th Amendment Citizenship Clause, we look to the English common law. That was the rule that applied from the colonial era on, at least for the colonists and for European immigrants. He then says, look, Chief Justice Marshall tells us in the Schooner Exchange what subject to the jurisdiction means, again looking to the English common law. Under English common law, if you are born in the dominions of the sovereign, you owe natural allegiance, and those who are present in the dominions of the sovereign owe temporary allegiance for as long as they're present. The only exceptions, again, at common law were ambassadors, people born on foreign ships, and people who were born during periods of foreign occupation. He then gets to the government's favorite page, 693, where he says, look, we have had this rule in the United States as to citizenship, at least for white Americans, from before independence. The purpose of the 14th Amendment was to embrace that universal rule of birthright citizenship, to embrace and incorporate the common law exceptions with the single additional exception of the pre-existing exception for tribal Indians that we had in the United States, which is an analogous exception, and that's the closed set of exceptions. You can't make sense of the holding in the case without looking to the controlling rule of decision, which is the common law. And I think my friend agrees that under English common law, domicile was not relevant, and the children born to temporary visitors in the territory of the sovereign were always considered birthright citizens.
Well, Ms. Wong, I mean, everything you say strikes me as, yeah, that's the way I read it too, but then what are those 20 domicile words doing there? Like, you can, take some of them and say, they were just summarizing the facts of the case, but not all of them. And why did they keep on, why did they sprinkle that in the opinion?
Well, I think, again, those were the stipulated facts in the case. And it's clear we have textual evidence in the majority opinion that they were simply saying this is an a fortiori application of that controlling rule that comes from the English common law. Justice Gray writes, again, after setting out the English common law rule and the exceptions with the single additional exception for children of members of Indian tribes, that the amendment in clear words and manifest intent includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States. And as was pointed out earlier, the very next part of that same paragraph, he cites to Webster talking about Thrasher's case, and he says, people who are born in this country owe allegiance independently of a residence within, foreign nationals owe allegiance independently of a residence with intention to continue such residence, independently of any domiciliation, and independently of taking any oath of allegiance, which is totally contrary to both the government's theory of dual allegiance or partial allegiance and to the theory of domiciliation.
I mean, I might agree with you if domicile had simply been sprinkled in the opinion.
Alito.
But
I hate that guy.
Kim Ark, it's a long opinion, but it begins by saying, here's the question, And it ends by coming back to the question. And it says, here's the question, stated at the beginning of the opinion, namely, whether a child born in the United States of parents of Chinese descent who at the time of his birth are subjects of the Emperor of China but have a permanent domicile and residence in the United States and are there carrying on business, and he states the diplomatic exception, and he says, for the reasons above stated, this court is of the opinion that the question must be answered in the affirmative. So why put domicile in? Sometimes it's hard to figure out what is the holding of the case. Here he tells us this is the holding of the case. Why put domicile?
Because that's where they live.
It's just something. It's
They
something
lived
irrelevant
here.
that he wanted to throw in. It's like whether a child born in the United States of parents of Chinese descent who once resided at a particular
I'm not gonna lie, I kind of low-key really hope he steps on Legos every morning.
Port of San Francisco. Why put it in if it's irrelevant?
Well, Justice Alito, I'll give you two responses. The first is that, again, it was a stipulated fact. The second is that regardless of what the judgment in the case was, which again was an a fortiori application of the rule of decision, the rule of decision in Wong Kim Ark has binding precedential effect. Even if you think that Wong Kim Ark decided the case based on the stipulated facts, you have to follow that controlling rule of decision. And if you follow that rule, you get to the same result for people without domicile. Wong Kim Ark says 6 times in the first parts of the opinion, as well as on the page the government focuses on, that domicile is not relevant.
Well, Ms. Wong, on that, what do we do with the fact that after Wong Kim Ark, at least some authorities
This is
took the
Gorsuch.
view that the non-domiciliary
Or wait.
question
Yeah, this
was
is Gorsuch, right?
decided,
It's Gorsuch,
Mhm.
yep.
remained
Okay.
open, and even continued to press the view that domicile is required. Now, I know you've got a lot of good stuff on your side too, but what do we do with the fact that many sound legal authorities thought it remained an open question, even if one of them wasn't John Marshall Harlan?
I liked your example from Justice Harlan's lecture here in DC. So here's what I would say. All of the government's citations in their brief generally either were rejected by Wong Kim Ark expressly if they
I'm talking
predated Wong Kim Ark.
post. If we're trying to understand how the legal community understood what happened in Wong Kim Ark,
Sure.
it seems to me it's a mess.
So-
And maybe you can persuade me otherwise.
I think I can, Justice Gorsuch. First, as to the post-Wong Kim Ark authorities the government cites, each one of them is inconsistent with Wong Kim Ark's reasoning or doesn't mention it at all. Most of them have very little reasoning at all. And in contrast, what we have on our side, post-Wong Kim Ark, is numerous federal court decisions around the time of Wong Kim Ark, between ratification and Wong Kim Ark, that said that domicile is not relevant. They cited Lynch versus Clark, which again was about the daughter of temporary sojourners. We have the 6th edition of Kent, which was cited in Wong Kim Ark, and of course was then cited after Wong Kim Ark was decided by many authorities, again, discussing temporary sojourners. Anyone who wanted to know what the law of citizenship was under the 14th Amendment after Wong Kim Ark would go to the 6th edition of Kent, where he says in that footnote on page 38 that the rule was Lynch versus Clark and temporary sojourners' children are U.S. citizens. We have members of Congress speaking on the record on debates on immigration laws, where they were finally passing these immigration restrictions that Senator Cowan wanted. And they all stated either that Lynch was the rule, that Attorney General Bates had stated the rule, again, citing Lynch, or Kent, and stating the rule that everyone born in the U.S. is a citizen, and saying, look, the children of Chinese immigrants, these immigrants who are unwelcome, these immigrants that Congress is now trying to bar from entering the United States, if their children born in the United States are citizens. We have in 1896, so a couple years before Wong Kim Ark, but in 1896, State Department regulation, which said the US-born children of foreign nationals are US citizens, accepting only the children of ambassadors. And then you have Marshall Woodworth, who is a US attorney who writes in a law review article that he's talking specifically about temporary sojourners' children, and he says, I don't think that's a good rule from a policy perspective, but that's the general rule.
Ms. Wang, can I offer a possible explanation for why
Alito.
Justice Gray made a point of putting domicile in what he said was the holding of the case? And it is
I
this.
hope his pillow's always warm.
Wong Kim Ark and his parents, had they come to the United States from Europe, could have been naturalized. But because they were Chinese, they could not be naturalized. And they had done everything that they could to make themselves Americans by establishing a domicile in the United States. And so that's what this was about. He couldn't get naturalized because of a racist law, but they had done everything they could to become part
Didn't
of the
they
American
return
society.
to China?
They did. They came to the U.S. to cash in on the gold rush. They were Chinese merchants.
Who were horribly exploited.
But they were here for a
brought to
while.
the
I mean, it was like
United
20
States
years.
to work
Yeah.
on the
Yeah, but it's
Transcontinental
like just like
Railroad,
where
to
do they
work
get this
in
shit from?
mines. They were worked to death.
And then they left.
were
So at the
treated
time Wong Kim Ark
horrifically,
came up,
but
his
they were
parents
not-
weren't even residents
they were
anymore.
overwhelmingly men.
Okay,
There
I
wasn't
was
an
hoping I
indication
was
that they
remembering
would
this
stay here.
correctly.
They could stay here. They didn't have permanent homes. And the opinion is drawing a distinction between those two categories of people who would have been well understood at the time when Wong Kim Ark was decided.
No, Justice Alito, I don't think that's a plausible explanation for why domicile is mentioned in Wong Kim Ark, because again, the controlling rule of decision based on the English common law and cases from Schooner Exchange to Lynch versus Clark to State versus Manuel, which was the North Carolina decision that said, look, the rule in the United States from independence on has been the English common law rule. That explanation would be inconsistent.
But Ms. Wong,
yes.
isn't that explanation, I take Justice Alito's point, and I think he actually
Jackson?
makes a good one in the sense that it could be that Justice Gray emphasized domicile to help the public accept the outcome of this case. You're suggesting that the emphasis on domicile was not
really
a part
quick.
of the rule.
Trump left the
Meaning
courtroom
he
halfway
wasn't
through,
saying
according
you
to
had
SCOTUS
be
blog.
like a foreigner who is doing everything
He
they
doesn't like
can
hearing
and
opposition
who
arguments.
can't be naturalized, but he might have
Apparently.
emphasized those facts.
Oh, he needs a nap.
In this case, precisely because
He said they're working to
Chinese
confirm,
immigrants
but
were
yeah,
unwanted.
they
Precisely
probably right on.
because he had to get this out into the public.
First president
and
ever to
people
sit
were
in on
gonna
oral
say,
arguments.
"Whoa, you're saying these people
Really?
have
I
this-
want to
this
talk
baby
about
has
this
to be a
after
citizen?"
too, because I have
And so
some
one could
questions.
imagine that it was important from a standpoint of helping people accept this citizen rule under these circumstances to emphasize that these particular
That
people
was
in this case
kind of my thought.
were in Justice Alito's first category.
I think that is very possible, Justice Jackson, and as evidence of that, I would point to the fact that if you look at the briefing in Wong Kim Ark, you'll see that even though the parties had stipulated in the district court that Wong Kim Ark's parents were domiciled in the United States, when the case came to the Supreme Court, the government's brief argued that it was impossible for Chinese immigrants to have domicile because they expressed the view that was common among people who opposed immigration by Chinese nationals to the United States. There was a common view that Chinese people were inherently temporary sojourners in the country. And so I do think it's possible, Justice Alito and Justice Jackson, that he was trying to dispel that notion and tell the government.
Absolutely. That at least it reads as though he's trying to calm everyone down. These particular people were domiciled, but we're following the English common law rule. And when you look at the English common law rule, domicile is not a factor.
That's right. I think, who knows why the majority opinion mentioned domicile. We know is a stipulated fact. We know the government tried to renege on that stipulation and rely on this assumption on the part of anti-Chinese advocates at that time that Chinese people couldn't form a domicile in the United States. And
Do we have the
follow
Exclusionary
English
Act?
common law rule.
Ms. Wang, can I move?
Yep.
Go ahead.
I just wanted to ask you a question about how the exceptions fit within the general rule. You've called them exceptions, and some of the common law sources call them exceptions, so I take that point. But if we think of use
Yeah,
solely
you're good, Lady
as
Google.
tied
You're
to
always
the
welcome.
territory, and we look at the exceptions as territorial in a sense, then they seem kind of like natural outgrowths of that rule, and this is what I mean, and this is where I want your help with how the exceptions played out in practice. If you look at Indian reservations as unique places because Indians were quasi-sovereign, separate nations in the American system, if you look at occupied alien territory as territory that's outside the jurisdiction of the United States, and then if you look at the diplomatic exception, almost like diplomats and their children had little bubbles around them, like the embassy is really the territory of that country, and even when they're traveling around, they're all not subject to the jurisdiction by virtue of this territorial fiction. Are those just applications of the rule? And if they are, then what happens to alien enemies like the German spies in Ex parte Quirin, or what happens to Indians who are actually not on the reservation but may be born, say, in Baton Rouge? How does the rule apply in those situations? Does it travel with the person, or is it tied in some sense to the land?
Sure. So let me answer each part in turn. So the thing that all of the exceptions have in common, again, is this sense that the person has this fiction of extraterritoriality around them. Let's set aside the Indian tribal exception for a moment and come back to it. So the example of enemy aliens, for example, Ex parte Quirin, is one that is answered by Justice Story in both Inglis and in Rice. And the touchstone under the American application of English common law was that in wartime, the touchstone is whether there's a foreign occupation of U.S. territory. So,
and that's, just to interrupt for 1 second to
Sure.
clarify, and that is territorial. Sometimes, it just seemed to me that the rule varied. Sometimes it was stated as enemy alien, and sometimes it was focused on occupied territory.
Sure. So the rule, I don't think there's a separate rule for enemy aliens, and the government's briefs describe the exception as an enemy alien exception. I don't think that is the best way to think about it. Rice and English tell you that when the British forces are occupying Castile, Maine, no one is subject to U.S. jurisdiction there because Britain is governing Castile, Maine. And Justice Story explains, look, if the U.S. then retakes that territory, babies who are born to U.S. citizens by what he calls post limine become U.S. citizens. So that's the way to think about any wartime situation, enemy aliens or otherwise. As we heard earlier, Professor Muller's amicus brief tells us how we've thought about enemy aliens in wartime. Even in World War II, when the United States was detaining Japanese nationals who were deemed enemy aliens of the United States, when those enemy aliens had babies in these detention camps, everyone agreed that those babies were U.S. citizens. And Professor Muller goes on to explain that there are many cases of those U.S. citizens going on to a lifetime of government service to the United States. Everyone agrees
such
those
a good
babies are
point.
US citizens like everyone else. So again, the touchstone for enemy aliens is
So what about Indians? What about the Indian who's off the reservation or born off of a reservation?
Sure. So to start with the basics, I'll refer to the Indian tribal exception just to use the term of art. The Indian tribal exception, Elk versus Wilkins tells us, comes from the constitutionally unique status of Indian tribes. In the Indian Commerce Clause, we know that tribes are treated as basically quasi-sovereign nations. We know that from the Marshall Trilogy of cases. We know from Worcester versus Georgia, where Chief Justice Marshall said that the tribes are essentially a distinct political community.
Well, I understand all that. So just in
Sure.
the interest of time, just to
Sorry.
focus you, I understand why the Indians are treated differently for purposes of the law, but I want to know, is it tied to territory or is it tied to the status of someone as a member of a tribe? Because if you're looking at it because of the special relationship of Indians to the United States as a matter of the Constitution, et cetera, well, I mean, citizens of France are citizens of a different sovereign as well.
Sure. So Elk versus Wilkins doesn't really answer that
Amy
question.
Coney Barrett, I'm
The
not
court
getting a
says
read
there are
on.
two ways
She's
to look
kind
at
of
this.
I don't know.
Either you look at it as the tribal member is like an ambassador. Or
She's
you can
definitely
look
a
at it
flipper.
like there's
Yeah.
a territoriality
I don't-
issue where people are born on tribal
She's kind of
lands,
teasing
and
the
therefore
answer
they're
out, if that
essentially-
makes
I think he
sense.
says, Justice Gray says at one point, we might as well be talking about someone who's born in Mexico.
Well, there's a lot in Elk, and some of it's not terribly helpful for you, it seems to me, because Justice Gray, again, strikes again, says that they may be
Gorsuch.
subject in some degree or respect to the United
Ari, I
States.
swear to God.
So there's some jurisdiction. He says they're born in the geographic limits. They are in a geographical sense born in the United States. But because they are not completely subject to the jurisdiction of the United States and owe allegiance distinct from the United States, that's what takes them outside. And that language sure sounds a lot like the Solicitor General's presentation today.
To the contrary, Justice Gorsuch, I embrace that part of Elk versus Wilkins' holding. Justice Gray, of course, wrote both Wong Kim Ark.
I know, and it's a struggle.
Sure. Let me try to help you out with that. The government tries to make it seem as though what
I'm
sets
still
the
feeling good
exceptions
on
apart, what
Gorsuch.
defines the
I don't know.
exceptions
Just that's the
is that
vibe.
the government has some maximum theoretical power.
I think we're going down an indigenous
government
people's
could
road.
have exercised
Gorsuch will
plenary
jump
regulatory
in.
power over the tribes, and therefore that's the same situation as a foreign national.
I was
in the
not
United
aware of that.
States.
Thank you.
But that's actually not true, because remember, if
Swear to God, Ari.
there's always this background notion, whatever the parameters of the relationship between the United States government and tribal nations at that time of ratification, there was this constitutionally distinct status of the tribes and tribal members, setting them, excluding from apportionment, which was renewed in the 14th Amendment. And that's not true of foreign nationals. If the government were right, that the question is what's the maximum theoretical power the government has, there would be no ambassador exception, because of course the United States could decide in some instance to go ahead and prosecute an ambassador. There would be inter-sovereign comity considerations there. That's how you define the exceptions. And as Wong Kim Ark says, Elk versus Wilkins has no bearing on the question of foreign nationals.
Ms. Wang, on the earlier answer you gave to Justice Gorsuch on the temporary
Sotomayor?
sojourners cases, those were distinct cases, correct, where the parents had come to the U.S. and didn't want to give citizenship to their kids, took them out immediately, correct?
I'm sorry, Justice Sotomayor, I'm not sure which cases you're referring to.
All right, that we can look at.
Okay.
Ms. Wang, would you agree that the citizenship test in the 14th Amendment is the same as the test in the 1866 Civil Rights Act?
So the words are obviously different. What Wong Kim Ark tells us and what the debates tell us is that the framers, it was the same Congress, obviously, framing both. Congress was trying to do the same thing with both the 1866 Act and with the 14th Amendment. They wanted to capture the common law exceptions and the Indian tribal exception. They started out with the two separate phrases, not subject to any foreign power, plus excluding Indians not taxed. And as Justice Gray described it in his majority opinion in Wong Kim Ark, they decided to switch to the affirmative phrase, subject to the jurisdiction.
Yeah, well, do they mean the same thing? And wouldn't it be very odd if
Fucking Alito,
the
I swear to God.
citizenship test in the 14th Amendment were broader than the citizenship test in the 1866 Civil Rights Act, particularly in the light of the fact that the
He's like not even trying to hide how he's going to rule.
Act was reenacted.
He never
after
does.
The adoption
He's
of the
usually
14th
easy.
Amendment and remained in place until 1940.
Sure, the framers were trying to do the same thing with the language in both.
Okay, so then I think we can turn to the language of the 1866 Civil Rights Act because it's more straightforward. Subject to the jurisdiction thereof is like the puzzle wrapped in an enigma, wrapped in a mystery, but not subject
really.
to any
What the fuck is that?
is pretty
Yeah, it's pretty clear.
So let me give you these examples. A boy is born here to an Iranian father who has entered the country illegally.
Iran,
that
of
boy
course.
is automatically
Good
an
Lord.
Iranian national at birth.
Fuck my life.
And he has a duty
Ooh.
to provide military service to the Iranian government? Is he not subject to any foreign power?
Not within the meaning of the 1866 Act, Justice Alito.
Thank you,
And that's
Ari.
clear from Wong Kim Ark, and it's clear from the debates. What the framers meant by the phrase "not subject to any foreign power" was referring to the ambassador exception. If it meant what the government contends, basically not a subject of any foreign power, that another country considers you a jus sanguinis citizen, then lawful permanent residents, all foreign nationals.
Well, ordinary public meaning of that would certainly encompass that boy, would it not?
Justice Alito, if you think that the language of the 1866 Act was ambiguous, as Wong Kim Ark says, the shift to the language of the 14th Amendment, which is the operative text, certainly clears up any ambiguity.
What I said about a boy born to an Iranian father is true of children born here to parents who were nationals of other countries. If I'm correct, it's true to a child who's born here to Russian parents. It's true to a child who's born here to Mexican parents. They're automatically citizens or nationals of those countries and have a duty of military service.
Dual
It sure
citizens.
seems like that's that makes them subject to a foreign power.
So they just want to get
But
rid
again,
of dual
Justice Alito,
citizenship.
that would have meant that
Well,
the
that's what was set out in
children of
2025
Irish,
project.
Italian,
One of the
and,
first things was getting rid of that
other
dual
immigrants,
citizenship.
which Wong Kim Ark refers to and the debate the framers refer to, would not have been citizens either. Because if the only test is whether that US-born child is considered a citizen by another country under their jus sanguinis laws, then no foreign nationals' children would be
in all of those cases, the parents could be naturalized, and then the children would be derivatively naturalized when the parents were naturalized. Wong Kim Ark, I'm sorry, the red light is on. Wong Kim Ark has a passage explaining how this court should treat dicta. And it quotes something that John Marshall said.
Back into the dicta measuring.
Quoting from Wong Kim Ark. It is well to bear in mind the oft-quoted words of Chief Justice Marshall. It is a maxim not to be disregarded, that general expressions in every opinion are to be taken in connection with the case in which those expressions are used. If they go beyond the case, they may be respected, but ought not to control the judgment in a subsequent suit when the very point is presented for a decision. So,
God, I hate dicta. I just hate it.
What's good for the goose is
The
good for the
fuck is
gander
this
rule. That's how
nonsense?
Wong Kim
They never
Ark
give a shit before,
treats
but when it,
what
you
was
know.
said in the slaughterhouse cases.
Ooh,
Should we
slaughterhouse.
apply that same rule to Wong
They're
Kim
fucking
Ark
on that
itself?
shit. Like, this is their big argument.
Wong Kim Ark
here.
tells you what to make of the slaughterhouse dicta. It was dicta. The issue of citizenship was not at play in slaughterhouse. And in contrast, the parts of the holding, the parts of the decision that I alluded to are the controlling rule of decision. Again, we look to
Slaughterhouse
the English
cases are
common law
gross.
in construing the 14th Amendment.
Well, it's the monopoly issue that was argued in front of the court.
Well, just a couple more questions. So if those who framed and adopted the 14th Amendment had wanted to limit the citizenship test to just those specific groups that you concede fall outside the birthright citizenship rule, why didn't they refer specifically to those groups? Why did they adopt a general rule? They could have said all
Is
persons
Alito
born or
wishing for
naturalized
some
in the
big
United
dicta?
States,
I'm just curious.
excluding Indians not taxed and those ineligible under common law, are citizens of the United States and of the state wherein they reside. Or they could have said all persons born or naturalized in the United States, excluding Indians not taxed and the children of foreign ambassadors or foreign invaders, are citizens of the United States and of the state wherein they reside. But they didn't do that. They adopted a general
It's saying
rule.
the same
So what's
thing.
the explanation?
I would say the Wong Kim Ark tells us what the explanation is, that the framers of the 14th Amendment, after overriding President Johnson's veto, wanted to adopt a universal rule with a closed set of exceptions. And they believed that subject to the jurisdiction of the United States did that. And that term does describe both the universal general rule and the common law exceptions, with the sole additional American exception for tribal Indians.
Thank you.
That makes sense.
Ms. Wang, I've not quite understood the Solicitor General's argument that lawful domicile somehow changes the U.S.'s dominion over a person or allegiance. Even in Justice Alito's examples, if your parents are Iranian, if you get lawful permanent residency here, that child still, by their laws, when it leaves the United States, must serve.
Thank you. I was
in the
thinking
Iranian
that same thing.
Well, I don't know the answer to that. What I can tell you is that under Wong Kim Ark, the court says, we don't care about problems of dual nationality. We don't look to other countries' laws in construing our 14th Amendment.
Ooh, we like that.
It was undisputed there that Wong Kim Ark's parents owed loyalties to China, correct?
Sure, yes.
What I'm saying is, even if you become a permanent resident, you're not a U.S. citizen. So your primary loyalty still remains with your citizenship country, wherever you came from.
That's right, Justice Sotomayor. I take your point now.
You understand what I'm saying. And during temporary, whether it's lawful or unlawful, temporary presence in the United States, you are subject to the U.S. laws, correct?
That's right. The question that the 14th Amendment asks is whether the U.S.-born child is subject to U.S. jurisdiction when they're born.
Meaning, are they within the U.S. territory?
Exactly, other than people covered by that closed set of exceptions.
Okay, thank you.
That's right. In other words, the government's rule, which really is looking at whether someone has a divided allegiance because they're a citizen of another country, would exclude the children of all foreign nationals, and that isn't what they're saying.
Exactly.
Yep.
So the only way that allegiance, lawful or unlawful, has no play in this question.
I would say that the relevance of allegiance is the relevance under the English common law rule that's embodied in the 14th Amendment. All persons born in the territory of the sovereign owe natural allegiance.
Except for the three limited exceptions.
Precisely.
Justice Kagan?
I think I'd like to take you back to the first question that Justice Alito asked General Sauer, and it was this question of what do we do if we think we have a new problem that didn't exist at the time of the 14th Amendment? I don't think, actually, that the U.S. government argues the case this way, but let's put the U.S. government's arguments aside and just ask something like, well, everything that you're saying would suggest an answer to the question of people who, the children of people who are temporarily in the U.S. but here lawfully. Is there any way that there might be a different answer with respect to the children of people who are here unlawfully because of this new problem issue that Justice Alito has raised?
No, there is no difference. And of course, the government's arguments as to people who are unauthorized immigrants in this country all runs through and hinges on their domicile requirement. The first thing I would say in response is that, once again, it's crystal clear from Wong Kim Ark and from the debates that the framers of the 14th Amendment meant to have a universal common law rule of citizenship subject to the closed set of exceptions. And we can't take the current administration's policy considerations into account to try to re-engineer and radically reinterpret the original meaning of the 14th Amendment. The second point I would make is that, in fact, the framers did consider the concept and the actual problems of immigration that were coming up at that time. In addition to this, notable exchange between Senator Cowan and Senator Conness, where Cowan says, if we have this citizenship clause as part of the Constitution, we are going to encourage these gypsies, what he called gypsies, Roma, in Pennsylvania, whom he characterized as invaders trespassers and lawbreakers will encourage them to come into our country because their children will be citizens. He says, Senator Conness, in your state of California, you will be facing a mass flood of Chinese immigration if we adopt the citizenship rule. And Senator Conness himself, an Irish immigrant, says, yes, and I am voting for that because I believe in citizenship by virtue of birth without regard to parentage. And the third point I would make is a historical one, which is that
was a mic drop.
at the time the framers are thinking about birthright citizenship, there had just been 15 or 20 years of unprecedented immigration from Ireland. The Know Nothing Party was dominant in the 1850s, just a decade earlier, and they were vehemently opposed to Irish immigration. They believed Irish Catholic immigrants were unassimilable and could never become Americans. But even the Know Nothing Party, members of Congress, believed that the children born in the United States to those Irish immigrants were citizens like anyone else. That's the intuition that the framers of the 14th Amendment had. Contrary to the government's arguments now, they wanted to grow this country. They wanted to make sure we had a citizenry to populate the military, to settle the country. And they also had an intuition that was consistent with the founding aversion to inherited rights and disabilities.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
On Lynch v. Clark, which you cite several times in the brief and today, which I appreciate, the government's response is that that decision was questioned at the time and went unmentioned in congressional debates about the 14th Amendment. I just want to get your response to that point on Lynch.
Sure, not true, though the Lynch was not specifically mentioned by name.
She said not true.
In the 14th Amendment
Yes,
debates.
and I love
a couple
that.
months earlier in the debates on the 1866 Act, where Senator Trumbull, Senator Lawrence talks about the great case of Lynch versus Clark, where it was conclusively shown that all children born here are citizens without any regard to the political condition or allegiance of their parents. And then, of course, they
Ari
discussed
really
the
is the
children of
best hype
temporary
person
sojourners
ever.
elsewhere without mentioning Lynch.
Just want to isolate a point that you've mentioned, which is if the 14th Amendment used the phrase not subject to any foreign power, to give a much tougher argument, and then earlier I think you indicated that that's what they meant, even though they didn't say it. I just want to give you a chance to unpack that, because I think that's
Sure.
If it said that, I think our history would be a little different, and I think the text, even put aside the history, because that's speculation, the text would be quite a bit different.
Sure. So let me answer in three parts. The first is that Wong Kim Ark tells us that, the court already dealt with this and said, look, the framers were trying to do the same thing with the language of the 1866 Act. To the extent you think that the language is ambiguous or not as good, let's look at the operative text subject to the jurisdiction thereof. The second point I would make is that it's clear from the debates that the framers, in using the phrase not subject to any foreign power, were thinking about ambassadors. And I believe that Senator Wade at one point says, well, I wanted to start with the phrase, all persons born in the United States are US citizens. But then I thought, oh wait, we have these temporary visitors. In fact, the government points to this quote. He says, so there are these temporary visitors we can't make and we can't make their children citizens. That's ambassadors, and that's very clear from that.
So if that had been the text, your argument would be that was understood to be narrower than its text would read.
Yes.
But that's not the text, so I guess we don't need to deal with that.
Sure, and that brings me to my third point, which is you can't read not subject to any foreign power the way the government urges you to without making the children of all foreign nationals non-citizens, and that's clearly not what the framers were doing.
Justice Alito and Justice Kagan raised an interpretive question that I think is important, which is, are the exceptions, you've used the word closed many times, frozen, or do we reason by analogy to the exceptions that existed based on things that were unforeseen at the time? This comes up in the Second Amendment now, comes up in free speech law, and how do we think about whether it's possible that there could be an additional exception based on modern circumstances, reasoning by analogy to the exceptions that exist. I'm thinking in particular about the non-citizens unlawfully in the country, not the temporary part, but the non-citizens unlawfully in the country.
Sure.
Could you reason by analogy? You've used
situation
the phrase,
changed. We get to now reinterpret the law a different way. That's crazy shit.
Fiction of extraterritoriality, and could that apply? And if not, why not?
Sure. So here, I agree with Professor Whittington, who says that the government's position here is not positing a new application of the rule, but a challenge to the rule itself. And I think that's right.
I see what he's doing here.
The 14th Amendment's rule does provide for a universal rule with a set of closed exceptions. Wong Kim Ark says so at least twice. It says in an earlier passage that the framers were not trying to introduce any new exceptions. To the contrary, they were trying to foreclose any caste-creating exceptions like the court had created in Dred Scott. The second reason is that the debates themselves had the framers saying,
that was literally Thomas's first question.
We are declaring what is already the law in this country, at least for white Americans, and we are putting any further exceptions to birthright citizenship outside the reach of any future Congress. They were very concerned about that. That's the whole impetus for the Citizenship Clause. And the third thing I would say is that that it would be contrary to the central purpose of the 14th Amendment Citizenship Clause to admit new exceptions. For all those reasons, the entire history of the Citizenship Clause is driven by the notion that we don't want to have any other exceptions.
And then relatedly, just a separation of powers point, but get your answer. I understand your point about the executive order, but Congress's authority under Section 5 of the 14th Amendment, I guess the answer you just gave means they don't have any authority to look at this, even if they passed it 435-0 in the House and 100-0 in the Senate and said, we're carving out a new, by analogy to the existing categories, a new exception. Your point is, no, they're closed, they're frozen forever.
Correct. And the way I would put it is
you would
that
need
the
to amend
Citizenship
it,
Clause
correct?
of the 14th Amendment,
Yep, that means it's frozen.
has a universal rule with a closed set of exceptions. It sets a floor. So the Congress has, under the Naturalization Clause, the power to expand citizenship to other people not covered by the 14th Amendment, and obviously they have in many ways, but they can't go below that floor that the Constitution sets.
I think Mr. Sauer acknowledged that, and you mentioned this in your opening, that if we agree with you on how to read Wong Kim Ark, then you win. So that could be if we did agree with you on Wong Kim Ark, that could be just a short opinion, right? That says the better reading is respondent's reading. Government doesn't ask us to overrule, affirmed.
Yes.
That's that. Then last question, though, why would we address the constitutional issue? This is the last one. Why would you address the constitutional issue given your argument on the statutory? Our usual practice, as you're well aware, of course, is to resolve things on statutory grounds and not to do a constitutional ground.
Capable of repetition yet evading review.
We obviously have these two paths to a win here. We're happy to win on either or both of them. I do think it would be prudent for the court to reaffirm its decision in Wong Kim Ark, where it's a landmark decision about the definition of national citizenship in this country. I just think it would be prudent for the court to go ahead and reaffirm that, but of course we're happy to take a win on any ground.
Thank you.
Thank you.
Justice
I'm
Jackson?
feeling a little better about Kavanaugh
I'm sorry,
right now.
Justice Barrett.
So I have a question about the exceptions again. So in your interchange with Justice Kavanaugh just now, you were talking about it as a closed set of exceptions. And said that way, it sounds like exceptions that people had in mind at the time of the ratification, but that were not explicit in the amendment. But I took your brief to be arguing that subject to the jurisdiction thereof is the language in the 14th Amendment that refers to those exceptions. Am I right?
That's right.
Okay.
It describes them.
It describes them. And would you say, this goes back to a question that Justice Gorsuch asked General Sauer, our relationship to the Indian tribes is different today than it was at the time that the 14th Amendment was ratified. Let's put aside Section 1401. is a tribal Indian born on a reservation today, on tribal land, a natural-born citizen under the 14th Amendment?
Under the 14th Amendment, no. Of course, Congress has provided for citizenship for all tribal members in the 1924 Act.
By statute. And so is that
Good
because what's subject to the jurisdiction of meant when you say closed set of exceptions? It means that the jurisdiction as it existed at the time of the 14th Amendment is still the jurisdiction today? So let me just be a little bit clear. Justice Kavanaugh asked you if we could create new categories by analogy. So there may be other sorts of people who were present here to whom this subject to the jurisdiction in the same way that we were talking about, the bubbles around ambassadors or the soil of occupied territory or the soil of tribal land. Perhaps those new carve-outs could exist by analogy today, like if the United States carved out some portion of some state and suspended it from its jurisdiction. Wouldn't the principle still apply?
No, Justice Barrett, for two reasons. The first is, again, that there is a closed set.
But why is it closed? The language doesn't say it's closed.
Sure. We know it's closed because the very purpose of the Citizenship Clause was to foreclose new exceptions. That's clear from the debates. And I would say that the language describes a closed set as well. Because it's
so from what I'm understanding, Barrett's trying to probe how far can Congress go?
They say, look, what if Congress, in order to do an end run, in order to change the meaning of the 14th Amendment as to unauthorized immigrants' children, Congress can say, we are not going to exercise jurisdiction.
Well, not quite, because it's redefining jurisdiction. It's not quite analogous, right? Because the government's domicile theory is a little bit different than the jus soli theory, right?
Sure, that's right. Yeah. I'm just saying that in the second step of their argument as to undocumented immigrants, where they have to get around the fact that undocumented immigrants, by and large, are domiciled in the United States, they're trying to say, look, we're gonna manipulate the law either to define domicile or to carve out, to say, just wave a magic wand and say these babies are not subject to the jurisdiction of the United States. There's still a missing factor under that original meaning of this.
This is Barrett asking the ACLU question.
There is another sovereign who can exercise jurisdiction over this person, even though they're in the United States. And this gets me back to the question you asked Justice Alito. The difference between an ordinary non-ambassador foreign national and everyone who's subject to one of those jurisdictions is that even if you take the government's argument and say a foreign national is subject to their country of nationality's jurisdiction in the United States, it's actually not true. If I'm a French national in the United States, France cannot come into the United States, arrest me, and try me for a crime under French law. And that's what sets ordinary foreign nationals apart from ambassadors.
Well, no, I mean, I understand. That wasn't quite the hypothetical. I understand that. Let me just ask you, no, that's okay. Let me just ask you one last question about Indians. So I gather what you're saying is that Congress cannot expand the set of, we'll call them exceptions, right? But you're saying it can't contract them either, and that was the Indian example. So what if, again, putting aside Section 1401, what if our relationship with tribal Indians has changed so much that we would say, no, Indians really are fully subject to the jurisdiction of the United States in the way any other, natural-born citizen is? You're saying that that doesn't change the constitutional status of Indian citizenship.
Let me be clear. What I'm saying is that the meaning of the 14th Amendment is we have to go with the original public meaning. And obviously, at the very time that the framers were, thinking about the 14th Amendment, at the time of ratification, that relationship between the United States and tribal nations was in flux, right? The government has made various arguments about Congress's authority, but the way the framers thought about it and the way that Wong Kim Ark describes it is that there was a unique constitutional status, unlike any other relationship.
Yes, this argument is about birthright citizenship
between the United States and the Indian tribes. And that is what gave rise to the pre-existing exclusion of Indian tribal members from U.S. citizenship, and that's what the 14th Amendment captures.
Justice Jackson?
So I want to understand how you are responding to the government's argument that because temporary visitors and undocumented immigrants are still governed by their home countries, and in the government's take on this, you can't have you can have allegiance to two different sovereigns. Those groups can't have the requisite allegiance to be subject to the United States for the purpose of the 14th Amendment. That's what I hear the government saying, but I do think that that seems to rest on a different understanding of allegiance than what was in the English common law, and that when we understand what the English common law thought about allegiance, you can see that you can have allegiance to two different sovereigns at the same time. This kind of goes back to Justice Alito's questions. I mean, I was thinking about this, and I think there are various sources that say this, that you obviously have permanent allegiance based on being born in whatever country you're from. That's what everybody recognizes. But you also have local allegiance when you are on the soil of this other sovereign. And I was thinking, I, a U.S. citizen, am visiting Japan. And what it means is that, if I steal someone's wallet in Japan, the Japanese authorities can arrest me and prosecute me. It's allegiance, meaning can they control you as a matter of law. I can also rely on them if my wallet is stolen to, under Japanese law, go and prosecute the person who has stolen it. So there's this relationship based on, even though I'm a temporary traveler, I'm just on vacation in Japan, I'm still locally owing allegiance in that sense. Is that the right way to think about it? And if so, doesn't that explain
Not my
why
favorite argument.
both temporary residents and
I will be
undocumented
right back.
people would have that kind of quote-unquote allegiance just by virtue of being in the United States?
That's absolutely right, Justice Jackson, and that comports with the plain text of the 14th Amendment as it applies to everyone born in the United States other than those subject to the exceptions that were baked in, a close set. You owe natural allegiance as a U.S.-born citizen. If you want to look at the parents of those people, and let's say the parents are foreign nationals but not ambassadors, the parents owe temporary allegiance.
Right, so the
under
babies
English
get
common
the
law.
permanent allegiance piece of this, and the parents get the local allegiance piece of this. So to the extent we're looking for allegiance, we have it.
That's right.
Thank you.
Thank you, counsel. Rebuttal, General Sauer?
So the allegiance, though, had to deal with whether you were acting as an agent of the other government.
Thank you, Mr. Chief
So
Justice. Justice Kavanaugh, turning to Lynch against Clark, that you raised didn't come up when I was talking about. Keep in mind that we say that it's questioned at the time. It's questioned by a higher court in the same state. The state of New York, in the Ludlam decision in 1860, specifically said that someone who's traveling or sojourning abroad, though born in a foreign country, is not born in foreign allegiance. So obviously there is tension within that very state, and that's what contemporary commentators noted. And I make a more fundamental point about that. Lynch is not interpreting the 14th Amendment because it predates it. So it's not looking at the language
still had
of the 14th
slavery
Amendment.
then.
It's looking at, what does the word citizen mean, for example, in the clause. So there's an anachronism to their reliance on it. And I think that turns to a point that
We in
Justice Alito
rebuttal?
emphasized. Once you get to that language of the 1866 Civil Rights Act, where Congress said not subject to any foreign power, clearly, we are no longer dealing with the British conception of allegiance because Calvin's case and Blackstone say whether you're subject to another foreign power is irrelevant.
This
to
from
whether
the
or not
guy
you
who
become a citizen.
mentioned
So,
other countries
again,
do this
the concession
many
to
times.
be made that those two mean the same thing, which this court held in General Building Contractors, that the Civil Rights Act has the same scope as the Citizenship Clause of the 14th Amendment. Once you're saying not subject to any foreign power, Congress has clearly departed from the common law, the British conception of allegiance, that monarchical
All right, that's
conception
not
of
true.
allegiance. They have adopted the Republican conception of allegiance, and there's all kinds of evidence going back to the late 1700s that that's the way they thought about it. And
What?
there was a reference, I think, in my friend's presentation about the Marshall Woodworth treatise from the late 1890s. That treatise also, just like Lynch against Tark, the language they quote is actually describing the case or the law, the status of the law before the adoption of the 14th Amendment. So, but if you actually look at the treatises we cite again, I mean, Wharton, Morse, Justice Samuel Miller of this court, Lesser, Black, Hall, Winchester, Taylor, Westlake, Balott, there's this consensus going from the time of the 14th Amendment onward, when they're looking at the specific question of temporarily present individuals in the jurisdiction, all those sources say their children are not citizens. And that goes both before and after Wong Kim Ark. You see a similar consensus actually in the congressional debates, where whenever it comes up, temporary sojourners, it's understood, the context indicates it's clearly understood that those children are not citizens. And I would therefore finish where
That's
I began with drawing a stark contrast and turn back to the first question that Justice Thomas acted. That Republican Congress in 1866 had a very, very clear understanding that the children of the newly freed slaves have the requisite allegiance to the United States. Wow. This was all about overruling the grave injustice of Dred Scott and making sure that allegiance was granted to the children of slaves. However, you have this contrast of a very, very strong, impressive consensus, both in the original understanding, in the congressional debates, and carrying over into commentators for 50 years afterwards, that the children of temporary sojourners are not covered. And for those reasons, we ask the court to reverse.
I wonder if Thomas just sits in that guy's office.
The case is submitted.
Whew,
Oh my goodness.
that's a lot.
Okay.
That was a lot.
So while we still have people here before they all start bailing on our boring conversation,
Oh,
I do have a video that I shot a while ago, but I reposted it because it's very relevant, expressing the exchanges between these different senators when it came discussing who's entitled to citizenship. And
ooh.
I found it fascinating that that Sauer was bringing up the arguments of Senator Cohen from Pennsylvania, because he made some really, really racist remarks, and then I'm glad that they hit it back on the ACLU's part, that no, he was complaining about immigrants, particularly what he called Mongolian or the yellow race, as shocking as that is, invading California and talking about, oh my God, what are you going to do, California? They're all coming to take your jobs. And then the senator from California, himself an Irish immigrant, Senator Conness, comes up and says, bro, sit down. We're good. I just want them all to have the same civil rights as any other American citizen.
Yeah, so I just want to chime in. Couple of things, guys. Please keep tapping the screen, or Ari will turn the comments off, and let's not get Ari mad. And please follow and gift everybody on the panel. I have two amazing attorneys here, Law and Attorney Di. I also have my podcast co-host, Lady Google, and then I have my girl, Ari, who runs her own lives, and she's amazing. So please give them all a follow, like, give, share, all the shits. I have so many questions, but I think really, and I'm not going to bring a lot of people up because it's just too overwhelming, and this whole case was just a lot. But here's what I will say: unless Law or Attorney Di, do y'all want to talk to people about this? Because I'll go with whatever y'all want to do.
I don't mind doing a bit of a Q&A. I am eating peanut butter and jelly right now, though, so is that okay?
Oh, yeah, you're fine.
Okay, cool, thanks.
Ken's the only one that has a heart attack while people are eating.
So I'm predicting a 6-3 at a minimum, or 7-2. I think Alito is completely in the tank. He did all the originalist pretzeling in order to defend the executive that I expected him to do. Thomas was relatively quiet, but his questions seemed to favor the government's position. My wild cards are of course, always, Gorsuch, Coney Barrett, and
Roberts?
Kavanaugh.
Okay.
And I think Roberts he's too much of an institutionalist to be like, you guys want us to overturn Wong Kim Ark without asking us to overturn Wong Kim Ark? I don't think so.
Good point.
But then there was a lot of discussion about domicile. And that's essentially, when you read the briefs, that's the government's core position. And they're trying to invent a definition of domicile that was absent. That they never discussed domicile in during the debates. I've read the Senate debates entirely. The House of Representatives documentation of the debates is significantly less robust, but the Senate has actual like verbatim transcripts of what was talked about on the floor. Not once
Goodness.
was domicile mentioned. And then they talked about, well, it was mentioned in Wong Kim Ark 20 times because it was just a stipulated fact. The parents were domiciled in the United States. There was no disagreement, so that's not going to factor into the court's analysis. The court isn't going to tear apart and question a fact that was just stipulated, but at no point in the Wong Kim Ark decision does it make the citizenship requisite on domiciled status.
Yes, I agree. I agree.
So here was kind of like my take on domicile, and I felt like they're trying to create this sort of like definition for it, and I got into like, well, how far does this go? Do you need a domicile to vote? Is it a one vote household? Is it or like, to be a citizen, right? Like, people going through the immigration process are currently being deported, even if they have a home here, they have X. So like, how far would this factor in? And they just get to pick and choose. And I don't think that there's any like concrete, like, to your point, I don't think it was relevant in the decision, but I mean, even if it was, like, they don't have any concrete purpose there or how they're defining it anyway, which is more problematic to me.
Well, and the government was trying to invoke some sort of permanent domicile thing, but even that fails in light of Wong Kim Ark, which again they made a huge mistake not asking for it to be overturned, because I can't see how they can possibly win. Unless they go with the statutory challenge, which is another question, which is another conversation. But I don't see how they could win without overturning Wong Kim Ark, because there's so much that is against their position, and they're hanging their whole hat on this domicile argument. Is the fact that at the time that the case was decided, Wong Kim Ark's parents had already returned to China. So it was not a permanent domicile relationship. We didn't have permanent residency in the 1860s like we do now. And the fact that they returned home showed that at least there was not any indication of an absolute guarantee that they were going to remain in the United States, which is kind of the argument that they were making, is that you have to have this intention. But then I liked on questioning, especially coming from Barrett, that, well, what about, we do have lawful permanent residents here, and their children are still, would still have all this birthright citizenship in Iran that Alito was talking about, but under the government's argument, they're still American citizens. So how can those two things reconcile?
Well,
that's right. And well, one thing too is that he went over to China with his parents, right, to get them all set. And then it was years later he came back in, just walked right through, and had already thought he was a citizen. And they stopped him and put him on a ship.
Yeah, 1890 he left. 1895 he tried to come back, and that's when they held him, and this case progressed.
Yeah.
Well, here's my prediction on this. I think Thomas and Alito, obviously where they're going to land is on the admin side, and then Kagan, Sotomayor, Jackson already on, so we've already got the 5 right there. Coney Barrett is the only one I'm absolutely out on. She's like sitting right in between, and I can't call it. Roberts, it's going to be, he's not with the admin. Gorsuch, I don't believe will be with the admin. Kavanaugh, a little bit more to the middle, but I kind of like that when he was probing the ACLU, he was like, well, if we do this or do this, how would that? And she was like, we're going to take a win either way. I felt a little bit more like he may have been on it. So this could be close. It could be 5-4, 6-3. But I don't think that the admin will prevail here. I just didn't feel that their argument was strong enough.
Did you guys hear that Trump is attending the oral arguments? Do you guys think he's doing that to try to intimidate the justices in a way to
Oh
kind of
no.
agree with them? I'm reading right now that he's literally attending the oral arguments apparently and is the first sitting president to do so.
He's already left. Like
He
he left a few hours ago.
And there's no way
Okay.
you can intimidate a U.S. Supreme Court justice. So let's just put that out there.
I mean,
Yeah,
he could try.
they've got life tenure. There's nothing he could do to
Mhm.
hurt them.
Yep.
I mean, he probably thinks it's an intimidation tactic, but they're just like, eat shit, you know, like that's pretty much going to be their vibe about it. Like, what are you going to do, bitch?
He already
I
called
just wanted-
Kavanaugh or not Kavanaugh, but Gorsuch and Coney Barrett rhinos.
No,
Already?
no. He said that the tariff ruling where Gorsuch came out, he was talking mad shit, and he was saying something about Gorsuch being like anti-constitutional, and I was like, calling him that is fucking wild. Like, listen, I don't agree with Gorsuch, but he's a pretty strict like textualist. That was a wild claim.
I just want to know who was in charge of explaining to Trump, like interpreting this all for him. Did they have like Sharpies and crayons and like a little notepad drawing in pictures so he could figure out how the arguments were going? Because that's the only way I can imagine he had a clue.
I hope there's a courtroom artist in there that caught him the befuddled look on his
Right,
face as
looking
he was
puzzled.
listening to all these case laws.
Bro,
Yeah.
like it's just at the end of the day, like this is gonna go whatever way it's gonna go, but like their argument reached so much, like in like dicta measuring contests and shit. Like it was just I can't say for certain. I'm feeling like 5-4-6-3 probably against the admin, but they did a better job than I thought they would do, but their argument was still dog shit.
Well, and
Yeah,
I
so
think
I
too,
think they-
with the inspector general, like, I don't know, Law, when you've hung out on other Supreme Court arguments, I've not heard of a situation where the government attorney was like, oh, I don't know. Oh, I'll need to just look that up. Or, oh, I didn't really develop that very much. It sounded like he didn't know his case.
Yeah, to be
Right.
fair though, they were asking about some pretty obscure things that I'm not sure I would have been prepped for either. So yeah, that's but like
What? Like
kind of
what?
one of the things that when Kavanaugh was asking about the Fifth Amendment applicability, where or not Fifth Amendment, I'm sorry, the fifth section of the 14th Amendment, to
Oh,
the ability
right,
to
right.
enforce it against the states.
Right,
I
right,
wouldn't
right.
have, that wouldn't have been on my bingo card of questions to anticipate.
Really? That's one of their favorite pieces of the 14th Amendment. I only say that because of the Colorado case, the Anderson immunity
Yeah,
case.
absolutely. Yeah, absolutely in that sense. But when we're talking about whether somebody has a federal right to citizenship, I wouldn't have anticipated a application against the states argument
Yeah.
or question to
Guy,
come up.
one of our
Interesting.
friends, Holland, is also a lawyer. She's in the comments. She says that she'll be surprised if Amy Coney Barrett rules with the government. Everybody, if you see Holland in the comments, make sure you follow her as well. She is absolutely brilliant with these types of topics.
Yeah, I love
I think that's fair. My six, if I had to put a pew to my head, my six would be her, Roberts, Roberts, the three liberal justices, and Gorsuch. Kavanaugh would be my wild card in that scenario.
I can see that. Yeah.
No, I'm gonna disagree. Coney Barrett is my wild card here. I'm more firm on Gorsuch. Kavanaugh and Coney Barrett would be my wild cards here, not Gorsuch as much. I don't know why, but it's just the way that he was sort of attacking. Like I just didn't feel like he was feeling it. I can't make it make sense, but Coney Barrett and Kavanaugh are my wild cards here.
Coney Barrett is always, you got to take a look at her teaching history. That's what I do. So she spent so long teaching law at Notre Dame. She's just very, this is what this is, and then walking it through. And so with a case this old, the way they're interpreting it, and because we're not talking about ABs, she's a jerk on that one. But I think that's the road.
She's a Catholic there, yeah.
That exactly. Are we Catholic? Are we not? Today we're not. We're just following like super old precedent. So that's the only reason why I would kind of lean towards her going with not the government. But yeah, she's definitely a wild card in every single case, though, in my opinion.
Well, usually,
go ahead.
I was going to say, usually I get a little bit more of a vibe on her, but she really felt very like I couldn't see the trajectory she was going to take. I can look at her past cases and be like, she is very much like more like willing to be institutionalist and things like that. But her sets of questions, it was just really hard for me to like see kind of where she was going to go. That's why she's more my wild card here, because they'll always surprise you and do some weird shit. And she was more, just harder to read.
Absolutely. Absolutely.
I think my only question is whether it's going to be turned over on statutory grounds or constitutional grounds, because the court could wimp out here and just go to the 8 USC 1401 argument about the subject of the jurisdiction. I hope that they don't. I hope they reaffirm Wong to include an actual affirmed interpretation of jus soli, absent any other amendments from Congress to the 14th Amendment.
Yeah, that would be nice. I mean, again, it is codified. We do have pieces of that. And so if they take away the federal statute piece of it and leave the Constitution alone, I don't know.
Then we're just going to be back here again.
I was
In 2
about
years.
to say, we're going to be back here, in a year after Trump passes another EO, getting around the language. Like, we're just going to be back here again. And
So that...
At some point, the justices just have to get tired of doing this. Like, do they get tired of dealing with Trump's bullshit? I need somebody to tell me it's yes.
Yes, I think
What
so.
do you guys think? What do you guys think about Justice Sotomayor's question about whether they're trying to overturn the Wong Kim Ark decision from 1890? That was the 1898 decision about the Chinese man that was born in the United States.
We know what it is.
Yeah.
Well, the government specifically disavowed attempting or asking the court to overturn Wong. They think that the domicile requirement is explicit in Wong. It is something that's a predicate for birthright citizenship.
Absolutely. Law, I wonder too if they're trying to say, no, we're not going to touch it because it is such an old case and there would be a lot of pushback. That was just something I had been thinking why they didn't want to use the name itself.
Yeah, I think that if that was their argument, they would have been this whole thing would have been about stare decisis, and they never would have gotten Roberts, Kavanaugh, or Barrett on that. So that's why my curiosity is about whether or not they're going to wuss out and go the statutory route in order to not, create, broad sweeping policy or not. I think in a lot of ways, this court is treating Trump as a temporary problem. So if they can kick the can down the road enough, then maybe things will return to some sense of normalcy.
Absolutely. I agree. Absolutely.
Just as a point of clarity here for whoever the fuck that is in the comments, this is my goddamn live and I'll talk however I want. And if you don't like it, you can scroll. Thank you so much.
Oh my gosh, was it redacted?
Have no idea. It's somebody I don't know.
Oh, somebody's been coming for a lot of the creators here. So let me know if you need a knuckle sandwich. I've got an extra, okay?
No, you're fine.
I
My
didn't
hands
even.
are rated E for everybody. I'm just throwing that out there.
I didn't even feel like Cass talked to me in a disrespectful way anyway. So
It's just how I talk. People just
yeah,
think
that's
I'm
just how
bitchy.
that's just how Cass talks. She's very blunt, which I'm cool with. So
Anywho,
I love saying that too. Like, this is just my face. I'm not angry. It's just my face, people. Just my face.
Laws met me. Like, am I just as much of a dick in real life?
Oh, I think you tone it down online.
Oh, thanks. I mean,
So
I'm cool with
sweet.
it though.
Yeah, that's probably true because I probably said some shit to Law that like I haven't said to other people. Anyway, back to birthright citizenship though. Okay, so just a consensus from the panel. Are we feeling like it's going to be for the admin, not for the admin? Just a simple one.
Not. I'm going 6-3 against.
I'm with Google.
Okay.
I
think
I
it's a
just
safe
don't know.
6-3.
Yeah, exactly. I think 6-3.
Oh, I'm sorry.
I was going to just say I would agree with the 6-3 possibility, but I'm going to need to hear it again and outline it before I've got a firm decision. If this had been 2 years ago, I would have said 9-0. But since the immunity case and since Dobbs, I don't even know anymore at this point. So I would need to think about it more.
I think I'm gonna go read through the oral arguments. I always pick out new things when I read it compared to when I listen to it. But yeah, my only question is how it's going to be turned over, if it's statutorily or constitutionally.
See, I'm going 5-4. That's my, I'm really predicting a 5-4 just because Coney Barrett was so hard for me to read. I'm thinking it's 5-4, but I think it's not in favor of the admin. But I would agree to Law's point. I don't know where they're going to go with this because Kavanaugh seemed more favorable to just sort of bitching out and not doing sort of the constitutional analysis there. So that's where I'm kind of like, I don't know. But yeah, that is a good question, Law. And I am curious where they'll go with that.
I'm interested too in the fact that people didn't really bring up the practical aspect of it, like the practical process of actually going through each of the hospitals, each person that was born, all of it. The actual implementation of something like this, it would take years to get it worked through.
Make that baby say the Pledge of Allegiance.
They, you know what? I'm just saying I had to say the pledge during my C-section.
Listen, they're going to tattoo an American flag right on their ass the minute they come out.
Here's what I would say though. I think it's positive that those things were not brought up because it kind of tells me a little bit more about the justices' kind of seriousness about this, because there are far-reaching implications of doing something like this. How would you go about it? How would you do it? Who qualifies? Who doesn't? What is domicile? And they went into domicile, but they never really got to like a core point on it, which bothered me more. And that was the question you told me to ask you again, which is about the domicile question. Like, what is going to be the qualifier here? What will qualify as a domicile? Is it an apartment? Is it a home? Is it a X, Y, or Z? How far will this sort of go should they decide that the admin is correct?
Well, and he also cited, I'm sorry, I just want to throw this out here. He also cited, they asked him specifically whose domicile, the child's or the parents, and would it be the mother's or the father's? And he was citing a case from like 1890 something. And then he specifically said the mother's domicile. Women couldn't even fucking own domiciles back then. We were still under our husband or father's protection and property. So what?
Right.
Well, I've done some looking at the history of what domicile means. It's where you are residing without any intention of relocating somewhere else.
Well, Law, my question real quick before you move on, because I'll forget my question. But my question is, we have domicile in so many different areas of the law. Like that was the other thing that was bugging me. Are we using the criminal law definition? Are we using property? Are we using probate? Or are we starting a whole new kind of domicile question, a new definition?
Yeah. Well, and so I went back to, like Johnson's dictionary, like back to the 1850s to try to see what did domicile mean there to whatever, holding it might have had on Wong Kim Ark. And basically it was wherever you are laying your head without an intention to leave. And it's not necessarily permanent because all of us have permanent residences, right? Like when you fill out your paperwork, doesn't mean you plan on living in that house forever. That's just right now, that's where you call home. And so essentially
Well,
domicile is when you go home, what's home?
what if you live
And
in a
yeah,
hotel?
right. Well, that could be your domicile. Like if you have no intention of living anywhere else but that hotel, then that's your domicile. If you're just visiting that hotel for 2 weeks until you go back to home, that's a different thing.
It still seems really, really vague. And that's
It's
sort of,
it's a garbage, yeah. It's a
Yeah.
garbage threshold to try and set, but also it's like it can't survive because if you're let's say you're here applying for asylum, you don't have legal status here, but your whole ass intention is to reside in the United States. That is your permanent domicile, and every intention in your bones says that that's your permanent domicile. But now, under the government's argument, they still want to exclude those people from having citizenship, so they have to go to the second step about owing allegiance,
Oh my
and
gosh.
they're just reading all of this extra stuff that wasn't present in the text of the 14th Amendment, and wasn't present in the debates surrounding it, and wasn't present in the cases that challenged the 14th Amendment immediately following its passage.
well,
Mhm.
that was one thing that kind of bothered me a little bit about this is that they never touched on a huge part of their cert petition, which I mean they did touch it on a bit, but it was more like vague sort of references to it. But they didn't touch on this political allegiance. What constitutes it? How are we getting there? How are we getting from A to B? What defines that? And then they come backwards towards this domicile, and it's just like you can't get a handle on exactly what they want to do. And I find this very problematic. Like they just want to do whatever the hell they want.
Yeah, Skelikos says, I live in a pineapple under the sea.
He's a silly person. We adore him. If you're not following Skelikos, go do it, everybody. He's hilarious.
Are you ready, kids?
I can't hear you.
My goodness, I'm having trauma.
F is for friends who do stuff together. Sorry.
I identify as Squidward.
That tracks.
Oh my goodness gracious.
Yeah, I don't know. I don't think they're going to favor the admin here, but again, it's just sort of more of like in that law. I wanted your response to this because something we got on a different trajectory earlier. Do you think SCOTUS is just tired of cleaning up after Trump at this point?
Yeah, I think so. I think, not since at least, maybe FDR to some point, but Andrew Jackson, have we seen a president so blatantly intent on challenging constitutional precedent to the point where he just does shit. Like, what did he do yesterday? The mail-in voting restrictions.
Yeah.
Like, that's just like facially unconstitutional, but he just does shit and says, well, I'm going to get away with it as long as I can until the courts the courts stop me.
Yeah, I was wondering, I'll text you about it, but I kind of wanted to go through that with you because there was some stuff I wasn't understanding, and I briefly read it and forgot to text you about it. So I'm reminding myself now.
But I saw this during some of Trump's first term where the cases that they were deciding very narrowly or, against him, kicking the can down the road, GVRing stuff, grant, vacate, remand. And I get the sentiment from the justices that they are just hoping that this is a temporary hiccup in our nation's history, and if they can stall things and kick the can down the road as much as they can, that things will return to normal and we'll have normal actors, in the presidency. moving forward, and we won't have to be putting ourselves into constitutional crises every 2 weeks.
I agree. My big question would be too, though, Law. I'm sorry to interrupt. I'm terrible. My panel etiquette needs work. Okay?
No, you are absolutely good, Di.
Here's my other question too. I've noticed, speaking to your point, Law, that the last, 18 months, it seems like the Supreme Court is like micromanaging the crap out of anything that comes in front of them, like any two little words in a sentence and so on. And I kept thinking, going through those cases, like, oh, wow, they are micromanaging. Why am I just noticing it now? And I think it's because that's how they're trying to kind of carefully tiptoe around what's going on with the president, to find just this little tiny piece and leave the rest of it open so it can come back up again at a different time.
Right. Yeah. And I mean, SCOTUS is always apprehensive to do broad sweeping things, abortion aside. But they're generally, they don't want to do broad sweeping things. They want to use a scalpel instead of a sledgehammer wherever possible. But in this case, we've got another 2 years of this guy. And God forbid one of his acolytes follows him. This is one of those things that I think SCOTUS needs to nip it in the bud immediately. Like something I wish they would have done with the tariffs is say, nope, you can only do the tariffs that have been authorized by Congress, and it has to meet the statutory requirements. But no, they just said, no, this particular one was outside of the bounds, but go ahead and do another one and get sued on that one, and we'll talk about it again in 6 months.
Exactly. Oh my gosh, so true.
That's what fundamentally bothers me about this SCOTUS. And I see your point, Law, because you are correct. Normally, they're going to want to, take a scalpel and not a sledgehammer. And in most cases, that actually works. But here's the thing. Time, money, taxpayer dollars wasted fucking fighting this shit through the courts. And then they get to SCOTUS, and then SCOTUS won't so we're back here in 6 months. And at some point, something has, I'm sorry, I'm ranting and I'm not yelling at y'all. Something has got to fucking give, because it drives me crazy. There are thousands of legitimate cert petitions that get submitted to SCOTUS, and we're having to put this shit aside because Trump wants to play dog shit games. And it's driving me crazy. And I'm sorry, I needed to go on my rant. I will calm down now.
That's his entire trope for his entire life as a businessman too, though, Cass. Like, he does shit and then he fights about it in court and he drags it out and he spends money and he throws money at it until the plaintiff or whoever is suing him no longer has any money and can't keep going. And then he claims he won. Like, that's what he fucking does.
And I just want to say, you guys already know that if they rule against the Trump administration, the worst people in your personal lives are going to be upset over this. Like, the worst people in the country are going to be upset that birthright citizenship was not overturned. I can already imagine it.
And those same people are literally American citizens because of birthright citizenship, so they can fucking cry harder.
Mm-hmm. Mm-hmm.
Like, low-key, I do love my stepdad, but he's an attorney. He's been an attorney for a long time. And, he's so smart. And I'm just like, you fucking vote for Trump. He drives me fucking nuts, but I hope this makes him mad because it'll make me laugh. I'm going to text him about it, and I'm going to be like, what do you think's going to happen?
Send him my video.
What did you say, Lo? Sorry?
I said, send him my video.
I will. I'll send it to him.
Include a picture of a ring around a toilet.
Will do. Oh my God, no! It's a long.
It's an inside joke. I'm sorry.
It's a long running joke between me and Google. I had a house fire, and my mom came over, and my two boys have a bathroom that they're 10 and 8, so it's not always the cleanest bathroom, but I clean it every other day, right? And she was mad because we have hard water, and there was a little ring in the toilet, and I was like, do you think anybody cared about that? She literally went out and bought me this ceramic scrubber thing because for some reason that was what she was upset about. Not the fire.
The contractors were gonna care.
Not the fire. The ring.
Maybe everything else was too much.
From hard water. It was it was crazy.
Eat off of the toilet? That's where my poop
know.
That she was going to do. That's where the booger sugar goes.
No.
I
No.
mean, maybe.
Yeah, RFK would have been disappointed.
Oh,
He's like,
no.
I'm not doing it off this toilet.
He's probably do it off a bar bathroom toilet. Let's be so
Or
real about where we're
you
at.
prefer to take a worm and then dip it in, get it all fluffy with the Coke, and then go ahead and put it up his nose.
Yeah,
Wow,
no. So
you're gonna catch a restriction.
No.
Oh,
I'm
Booger
a happy
sugar.
person. No bullying here.
So yeah, I told Google about that, and like she was like, "What the fuck?"
I can't let it go. Now, anytime her parents get mentioned, I'm like, show them the ring around the toilet. Like, I'm devastated.
I mean, I don't know how I can live with myself, you know. But anyway, back to birthright citizenship.
Sorry.
No, we're good. We're good. I got off on a little tangent about my mother being weird. So
Oh no, I'm worried about getting flagged now. Thanks a lot, Law, for nothing.
Well, you're the one talking about Coca-Cola.
Oh, you're right. All right, back to the citizenship.
Hey, 300 people in the room. We can get cast to 300K very easily. Everybody tap the bar until it fills up 2 times. That should get us about a quarter of the way there.
Ooh,
I have a
love
question.
that.
What case did he reference that? And I don't remember if it was Roberts or Gorsuch that was like, I wouldn't go with that case if I were you. It's not going to help your argument. What I missed what he was talking about.
Wong
but it
Kim
was so
Ark.
funny.
Wong Kim Ark. The government started invoking Wong Kim Ark, and Gorsuch was like, I don't know how much you want to rely on that.
Right.
Oh my gosh, I missed the first 10 minutes. And they were talking about Wong Kim Ark? Oh my gosh.
That was passed during a time when racism against Chinese... Oh.
Right. Yep.
Sorry.
So literally in the opening argument, they dropped the slaughterhouse cases. Like that was their quintessential case that they dropped, and then they got into Wong Kim Ark.
Okay. I missed that part. And then that's where you're talking about, Law, where you're saying he jumped in and said, don't use that one.
Yeah, because the government can't sidestep around the fact that they didn't ask to overturn ARC. So then they're left with trying to embrace it and redefine it. And so when the government started talking about ARC, then Gorsuch was like, well, I don't know how much you want to rely on ARC. There's not much helpful for you there.
Oh, and just for clarity for people in the comments, if you did miss some of it, shortly after I get off of here, I do upload, or at least try to upload all my Supreme Court like oral argument stuff to YouTube. My YouTube is Cast as Court, so if you want to watch the whole thing all the way through, it'll be over there. I do cut it down just a little bit, especially in the beginning, so you don't have to hear me ranting. But yeah, I'll cut it down to where we start the case.
I'm only here for the ranting. I'm only here for that. You gotta do more ranting.
I can. Law, Ari, and Goose can certainly attest to that. I can rant.
It's my favorite part of Cass.
I've had to hide the green lady here. I've gotten into a lot of trouble, losing my temper a couple times, so I'm living vicariously through others now.
Well, I have too. I kept getting banned, so
Didn't stop you from talking Alito, though.
That's right.
Listen, all I'm saying is I hope he steps on Legos, and I hope his pillow's always warm. And like, every time he gets in his car, it's just like almost out of gas where he doesn't know if he's going to make it to the gas station. And like, I hope that
he catches every red light.
Yeah, like that's all I'm saying. Like, and
if he doesn't like it, he can do like his flag says and appeal to heaven.
Hey,
that's right. Although my question is, who keeps summoning him? I mean, he can't stay here for the whole time. He's got to go back where he came from, right?
Hey, Law, can you make me a sticker that says F Alito, but actually uses a word so I can put it in my chat? Because I rant more about Alito than any other justice. I will give Clarence Thomas a lot of leeway. I'll even give, when Gorsuch is making me mad, I'll give him a lot of leeway. But it's just like Alito starts talking and I cannot. I just see red and I'm like, I hate you, you inconsistent bastard.
Yeah, I'll put it in the law shop.
Love it.
Love it. Love it.
Law
Right, I
has
hope
great
his bald.
stuff. Law has
I hope
great
his
stuff.
bald.
Yeah. Yeah.
Oh, sorry.
She's got
Go
the mug
ahead.
there. I just
Yeah.
read it for the articles.
Yep.
That's
Oh my gosh. Where do we get that?
I chimed
So
in
if
on
you
this one.
Yeah, if you go to lawofthewild.live, I've got a shop there. It's just a print on demand shop. I literally make no money on it. I just make things that make me laugh and make it available to people.
I love it. Okay. There we go.
I need a whole shirt that just says F Alito. Like that's just what I need. I
So
need
We'll,
that.
we'll
And
do
I
a
will,
product line.
I
We'll
will
put it on
wear it.
mugs.
I will wear it every live. Like it just say F Alito.
Shut up, Ari. Nuh-uh.
Could be Felito then, right? It's too much.
Wait, what?
That one was too much.
Right? I'm
My
over
bad.
here like, what? That's a thing?
The TST.
I have no idea what you're talking about. I'm totally lost right now.
The Satanic Temple.
Oh my God. Okay, now I know what you're talking about.
Did you get into a fight with them?
No, this is the name of one of their clinics.
Oh my gosh. Okay, I was gonna say because I adore them. They're fabulous people.
Very humanist.
They're First Amendment warriors. I love it.
Listen, I mean, I'm here for it. More people
This
need
is
to
the
talk
best.
shit. God damn it, RJ, stop turning off people's microphones, you turd.
I saw him come in. I knew he was going to cause problems.
I swear. I don't even have a lot more words for this. This was absolute dog shit, but I love that whoever the clerk was that got this scheduled on April Fool's Day is my personal hero, and I will send them a fruit basket. I'm just saying,
Ooh,
it was
fruit
great.
baskets. That's amazing. I am going to try to, by the way, read through Wong Kim Ark tonight on live. So if anyone wants to swing by, I will be kind of pulling that case apart a little bit.
I love it.
That sounds fun.
I will totally be there, Di, because I just go in her live because it's so soothing to listen to y'all just read it. And I'm just chilling, making dinner or whatever and listening. I love it.
Well, yeah, I mean, we have a strict no schmatzy rule. And so I think that really makes a difference.
Absolutely.
I tell everyone to follow Di, but she's only now seeing me for the first time ever.
Oh my gosh, look at that. Oh my gosh, we can't have a plus sign anymore. My bad. Here we are. We're friends now. Woohoo. I'm glad you mentioned that. Let me see. Who else? Let me get everybody else up here.
You could get me. I'm just saying. I'm fucking awesome.
Check and done. You betcha.
I fully endorse Law, Attorney Di, Jonathan, Lady Google, and Miss Ari down there. They are great follows. If you're not following in the chat, please give them all a follow. They are totally worth it. You can also give me a follow if you want to. Even if you just talk shit in my comments, I'm kind of cool with it. I like to make response videos, and I haven't had enough MAGA trolling lately, so get up in there. But yeah, anybody got anything else or anything y'all wanted to bring up or discuss that you thought was weird today?
I never do this, but I'm going to do a little self-promotion. There was a video that I posted right after Trump did his EO. I spent a lot of time on it, and of course, TikTok being TikTok, it's 6 minutes long and nerdy, so it didn't get any traction. But I just reposted it. So if you guys would go after this live is over, watch the video, share it. I go deep into the Senate debates around the 14th Amendment, as deep as you can go in 6 minutes. Which, if you're talented, you can go pretty deep in 6 minutes.
I was gonna say that's
amen to that.
Hey.
Mhm.
Bye.
That's the best 6 minutes ever.
But if you could share that around, I spent a lot of time on it. It should provide some context and was actually a perfect encapsulation of some of the arguments that were made today. So it makes me feel weird, but please do share that and honor the work I put into it.
Like always, Law is an overachiever. 6 minutes is above average, in case you didn't know.
Listen, I'm going to say it like this. There's 248 people in here. If you don't go like that video, I will get you. As Law's paralegal, I will hunt you down, and we're going to sue you for intentional infliction of emotional distress. So please go like his video. I already liked it for you, Pookie. I got you, and I reposted it.
Grumpy Monk says 6 minutes is long. No, the video is 6 minutes long. The work that went into the video was significantly longer.
It's like a week of work.
And I remember because I was talking to him about making that video, and then he got mad because he was like, I swear to God, it's like I did all this work and I'm like, you got to break it up into like 2-minute increments because people have like ADHD brain on TikTok and they're just the worst. Anytime I post a long video, it's just like dog shit. Like, I just don't get it.
Holland says liked and reposted, and not only because I'm slightly afraid of Cass.
I love you so much, Holland.
I love Holland. She is my favorite.
Oh my goodness.
Where is this video? Where is this video located, Law?
It's his very first video on his page.
Yeah, so I basically just reposted it. So I downloaded it and re-uploaded it.
As your secretary, paralegal, and Discord manager, Law, your stuff, like when you post a video, isn't like auto posting over to your Discord anymore. So I don't know if it's a bot or whatever, but you may want to fix that. I meant to tell you, and I totally forgot.
Lawbot is letting me down. Thank you for letting me know.
I wanted to tell you, Cass, that I'm going to be getting my paralegal certificate now that I don't know where I'm going to go next. And so I'm going to be coming for your job, just so you know, as Law's paralegal.
Oh, congrats, though. That's very exciting. Oh, my gosh.
Jonathan, I want to be so clear that I will and can fight you. And Law, you too. Don't you dare get rid of me. I'll have something to say.
Maybe Law could use another
Jonathan,
paralegal.
you got to go through me first to get to Cass. Like, no.
There's only one way to settle this drinking contest.
That's right.
Oh, great. Cass is going to kick my ass on that. I'm a lightweight.
I am literally offended that you're even considering it, Law. You're hurting my feelings.
Or I have a high confidence in the outcome. You could think of it that way.
That's how I'm thinking of it. You bet.
High confidence isn't absolutely not. So I'm going to need an absolute no.
Listen, I can drive there faster than she can get on a plane. I'm just saying.
I'm about to be domiciled in Minnesota. So.
Oh my goodness.
Is it your permanent intention, though?
Yes.
Yes.
What about the cartilage?
I will have the administration deport you from Minnesota.
We're going to fight later. I'm just letting you know that. Just fucking with you, by the way. It's a joke. But anyway.
All right. Well, with that, I should probably head out, actually, my dear friends.
I've got court in an hour, so I should probably get ready for that.
Oh, well, I can still do 30 minutes, right?
I got to go adult and shit. So thank you all so much for being here. I'm literally fucking with you, Law. So I'm not like I'm kidding.
But no, you're not going to actually fight me.
I need to clarify it for the chat so they don't think like I'm actually out here fighting people. But anyway,
disclaimers are good.
Cass is not kidding when it comes to me, though.
Actually fight people. So
Buc-ee's is not subject to the jurisdiction of the United States, so be careful.
What the fuck it is then? We'll make it that way. People would come up and say crazy shit to me, and I'd be like, they would like threaten to do something to me, and I'd be like, pull up. Like, what Buc-ee's do you want to meet at? Like, I don't care. Like, we can go. They never wanted to meet up after that.
God, I remember the Buc-ee's parking lot conversations.
Listen, you know what? Anything goes in a Buc-ee's parking lot. That's all I'm saying.
Real quick to recap for trees before I head out here. Did not go well for the government. The general consensus among us is government's going to lose. It's just how they're going to lose and by how much.
Yeah, pretty much. I was saying 5-4. Some people said 6-3. I don't think we got any like 7-2s or anything like that. But yeah, I wasn't feeling the government's argument was landing as well as they wanted it to. But it landed better than people predicted, if that makes sense. Okay, guys, since everybody has to adult and do the shits, I love you all. Law, thank you so much for being here. Attorney Di, Jonathan, Googs, Ari. If you're not following, go ahead and give them a follow real quick. And thank you so much, chat. Y'all are amazing. And I love you all being here. And I'm going to go ahead and head out. Love you guys.
Bye. See you later.
Bye, guys.